Good morning, Gesh, and all members on the platform. I just want indication, Gesh, if members have joined or they're still joining.
Morning, Chairperson. We have some members on the platform, Chair. We have Honourable Billy, we have Honourable Pala, and then we've only got one apology from Honourable Madupi. And apology, we've got Honourable Noe as well. So we've got 3 members plus yourself, Chairperson.
Okay. Can you check others who haven't submitted the apologies on their whereabouts so that when we start, at least we know that we have noted apologies if we have.
Will do, Chair.
Okay.
Chairperson, good day. We have a quorum, Chair. We may start.
Okay, thank you, Gershwin, and thank you, members on the platform and members who have joined us from the department. One would want to acknowledge your presence in this meeting. Gesh, can you start by flighting the agenda? Thank you, Gesh. It's already 10:01, and as indicated, we are meeting the quorum for today's session. The agenda is before us, honorable members. It will be opening, welcome, and introduction by the chairperson, apologies, adoption of the agenda, and then we'll go straight to our item, of which is consideration of the Immigration Amendment Bill, B8B 2024, of which we know it's Section 75 bill. So members, you all know that on the 12th of November 2025, the committee received oral presentations from 5 representations, and the committee agreed that the presentations and hence the deliberations on the Immigration Amendment Bill. We also received responses to the submissions from the department and the parliamentary
recording in progress.
Advisors. Members appreciated all inputs and made and noted the importance of the bill in strengthening the rule of law as well as judicial oversight. Today, we are proposing the adoption of the amendment bill and the report which has been circulated to members of the committee. We all know there was a process to date, members, that all of us have been involved with through the guidance of the legal advisors of Parliament and as well the department. With that being said, I think we all know each other, those who have joined the platform from the department and ourselves. So I won't want to waste time in terms of the introduction. But I want to indicate to those who are following through that members who have joined this meeting today are members of the Select Committee, Security and Justice, as you know them. And the department as well would be led today by DG Advocate Malagata. So for now, I would hand over to you, Gesh, for apologies as I declare this meeting officially opened.
Good morning, Chairperson and members and Department of Home Affairs and also the legal advisors. Chairperson, we have apology from Honorable Madupe. She is on study leave at the moment. And then also from the Deputy Minister, Ms. Nzuza. He's currently flying at the moment, Chairperson. Thank you.
Okay. Thank you, Gershwin and honorable members. Members, I put before yourselves these apologies for the adoption and consideration and as well the adoption of the agenda. I'm now noting hands, members.
My gadget is not raising hand. Let me hand it like that. Share.
Yeah, Honorable Billy must actually conduct some training this last term. So that next year you know how to raise your hand on your gadget. Over to you.
No, sometimes, Chair. Yeah, but I've got a toy gadget. Chair, thank you so much. Good morning to you. Good morning to all members and the Secretariat and the distinguished guests. It is really a pleasure once more to meet you. Chair, on the apologies, okay, I think what I was going to raise, because the DM did call me the same thing, so there's no need for me to place on record that he did call me and actually indicated the same thing that the Secretary has indicated, with which I agree. But I wanted just to indicate, Chair, that I would like to be excused, let's say, 10, is it for after an hour? I've got just a brief meeting with my provincial team drafting something, and but it will be about 30 minutes, and then I'll come back. And then, subject to that, I move for adoption of the apologies, for acceptance of the apologies, Chair, as presented. Thank you.
Thank you, Honorable Nonkonyane. But in future, please, you and your collective of the Eastern Cape, you must make sure that your work doesn't disrupt with the Select Committee, because here as well, you are the whip of the committee. So you are very important for all these sessions as we, go through this, as we proceed with these meetings. So I hope it's for the first and last time, because we don't want to create a precedence that our meetings clashes with the other work or commitments that we have as members of this committee. Members, Honorable Nonkonyane have moved for the adoption of the agenda and the apologies. Can I have a hand that is seconding with the amendment that he is putting forth his apology due to other commitment, but he will come and join back.
Morning, Chair and colleague.
I second the adoption.
Okay, thank you. You are in order. I nearly thought you were in pajamas, but I know you never disappoint. The agenda and the apologies, members, have been adopted and seconded. Thank you, Honorable Norway. Gershwin, can you fly the agenda before us? Thank you, Gershwin. Members, now we are on item consideration of the Immigration Amendment Bill, B8B 2024, as alluded that it's section 75 that has came before us as the NCOP. Members, we would have further inputs from the department and as well discussions with regards to their input. And item number 3 will be consideration and adoption of the committee report on the Immigration Amendment Bill, of which this part is our last part with regards to us as well, following through what needs to happen up until the bill gets to be adopted at the NCOP. So members today will be considering this report so that come the time it goes for the NCOP sitting, at least all of us, we are abreast to date, because that's what it's left from us in terms of this particular bill. Then we will have closure and way forward, noting that we would need to indicate to the Minister of Constitutional Development and Justice and the DM to join, on the basis that we know that during this, actually on Wednesday, they attend the cabinet meeting. So they are in a cabinet meeting as we speak, but we'll indicate to them to join the meeting while we are actually having some break as members. Because we know that this meeting that we have called of item number 2, it's on the basis that when we were dealing with the matter, the minister and the DM were not present in our meeting. And then we agreed that we must call them for follow-up so that we get sense on their commitment and undertakings with regards to the item that we'll be dealing with. So when we get to that item, Department of Home Affairs will be released and we would continue with the next session. With that being said, I would now hand over to the Department of Home Affairs, advocate for further inputs with regards to what has been done from when this matter was brought to the select committee till to date, and your remarks with regards to the work that has been done and that have been noted during our deliberations. Over to you, Honorable Tate Makataka.
Good morning, Honorable Chair, and good morning to honorable members of the Select Committee, as well as members of the public and colleagues who are on the platform. Chair, let me first submit our apologies relating to the meeting that the Select Committee had the last time. And as you will recall, Chair, we had indicated that I was in Cape Town waiting for a cabinet meeting where we also had an item on the cabinet agenda. And we had to rush because we then got called to deal with the agenda. So we just wanted to submit our apology that we were unable to stay in the meeting up until it ended. But Chair, we did get the questions that were raised by members of the committee during the committee's deliberation on the bill. And as we understand, the issues surrounded issues on children, on how we deal with children, and that there are no definition, or in the Immigration Act that there is no definition relating to children or what a child is. Chair, the first thing that we wish to submit to the committee is simply that the bill seeks to give effect to the 2 constitutional court judgments. And in effect, when we look at the 2 judgments, there is an order relating to the read-in mechanism in the event that Parliament, together with the Minister of Home Affairs, had failed to legislate on the impugned provision, and there is a read-in mechanism wherein the Constitutional Court had then indicated that when we read Section 34, there is a particular way that we need to read that Section 34. And in effect, the bill that we have currently before the committee is simply more of taking on board what the order has indicated, and similar to what the order has indicated, save for the parts that we needed to cure that were then deliberated on and ventilated during the portfolio committee meeting deliberations on the bill. So with the definition, and I think that most of the issues that have been raised, or most of the issues that have been raised as they relate to the children, those are policy issues that we have taken on board, and we just wish to submit also to the select committee that there is a process that is underway within the department in the development of the white paper on citizenship, immigration, and refugee protection. Once that policy has been adopted and approved by cabinet, that would then the policy that would tell us what and how the Immigration Act will need to be amended. And so some of the issues that have been raised during the oral representation as well as the written representation stages, we will then take on board and deal with it as they are policy issues. Similarly, we want to submit that when we read all the laws in the Republic, of course, we need to make sure that we read the Constitution itself. And there is a particular definition of what a child is, as contained in Section 28(2) of the Constitution. It then tells us what a child means. So we should not read the Immigration Act outside of all the Constitution as well as the Children's Act. There is also a definition there, but it's a policy issue again, and we have taken that on board, and we'll need to deal with it as we further develop the white paper. Secondly, Chair, we want to submit that there is a particular operational process that we follow when it comes to children that we come into contact with, and those children are not detained. We then have an operational way of dealing with children that we may have found that are either in need of care and protection. And in that circumstances, Chair, we then follow the provisions of the Children's Act, and we engage with the Department of Social Development, and in effect, we hand over those children to the Department of Social Development for them to then deal with them as mandated in terms of the Children's Act. So in our facilities and anywhere, we do not detain children. We treat them differently, as it were, in terms of the Immigration Act, or if they are under the circumstances that they may need protection from the Republic in terms of the Refugees Act, then the Department of Social Development will come back to the department and indicate how we need to handle that child in terms of their processes. But we follow the processes of the Department of Social Development. Again, we do note that the Immigration Act does not specifically deal with what must happen when we come in contact with unaccompanied minors. Again, we wish to submit, Chair, that this is a policy issue, but we have taken it on board, and we would also need to reflect on it when we deal with the white paper on citizenship, immigration, and refugee protection. And then we'll then get guidance in terms of the policy directions. And then if we then are of the opinion that indeed the Immigration Act needs to have a provision specifically dealing with unaccompanied minors, then we'll deal with that with same in that respect. But when we look at the Refugees Act itself, there is a provision specifically dealing with unaccompanied minors and those who suffer from mental disability, in terms of how we would need to process them under the Refugees Act. But again, with the involvement of the Department of Social Development and social workers, as we are directed by that department. Chair, I think those were the issues that we needed to comment on. Save again to say that this bill that is before the Select Committee is simply looking to deal with the issues that have been raised by the two Constitutional Court judgments, as well as the read-in mechanism that comes out from the order of the Constitutional Court in those two judgments. Thank you, Chair.
Thank you, Advocate Malakate, for precise input and as well your consistency in terms of indicating that the immigration bill before us is to deal with two constitutional court judgments, and as well noting issues that have been raised through public participation and what we have addressed during the oral representations by those who have written to us that they were available for oral reply. And I note as well that you have dealt with the issues that were raised by members with regards to dealing with children and those who might need health support interventions, of which you indicated very clear that in reading and rectifying this bill, you made sure that you were reading it along with the constitutions and the act that are there before us as the department, which is the Refugee Act that speaks to other issues on how to process cases of minors and as well those who need health issues, and the protocols thereof, operational protocols when you deal with children and minors. We have taken note and cognizance of, and one has learned through this particular process, members and the public who are following this meeting, is that we need to do more in terms of civic education on the interpretation that the Malakate of this act, because sometimes people read them, confusing each other, and yet you would find that people would lament and speak more on what needs to be done and be addressed by the white paper that it will be coming before us that will deal on citizenship, immigration, and refugee protection. So we are very happy for your input. And now I would now note the hands from members with regards to inputs and clarity that have been given by yourselves, if there's any. Honorable members, I'm noting hands. All right, thank you. I see Honorable Billy, Honorable Gerik, and then it will be Honorable Norway and Honorable Pal. Over to you, Honorable Billy. Honorable Billy. Honorable Billy, I'm not sure if you are hearing me on your side.
I'm just struggling, Chairperson. My connection is a bit bad.
Okay. I can hear you clearly. You can continue. Over to you.
No, Chair. Greetings to yourself and greetings to the honourable members and the department. Chair, I'm going to be very brief because I think we had exhausted the discussion in our previous meeting. But I do also maybe just want to again commend the department and also commend the process of public participation that was embarked on. As I did indicate in our last meeting, expressing appreciation to especially the young learner that had made contributions to this, and also, emphasizing the need for people to be able to direct their frustrations into the processes that are provided for by our parliament, our constitution, and that they get involved in helping us guide legislation in dealing with issues of this nature. And I also just want to maybe use this opportunity again to call upon those who are, who are concerned about such issues to use these processes. But having said that, Chairperson, in closing, I do also want to encourage that the inputs that have been made through this process, including Parliament, including participation, public participation, that they be taken into consideration in the finalization of this and the regulations and the details that will follow after this. Because if that doesn't happen, then it makes that participation, look as if it's a box ticking exercise, and we certainly do not want to do that. So there were really valid concerns which were brought up, especially when it comes to issues of capacity of the department, and it being able to ensure that this works the way that it should. So those are the things that I think needs to just be taken into account, Chairperson. But otherwise, we certainly do not have any objection. Thank you.
Thank you, Honorable Pili. What I want to just note as something that we would need to piggyback from is us as a cluster dealing with this issue of capacity, maybe come the next term, because I take note as well on the emphasis of people raising their frustration during this legislation processes. And perhaps if we give it an attention on its own and get sense what is happening in all these Home Affairs department, we would be able to, come with tangible solutions for our committee to deal with in terms of pushing and intervening on issues that Home Affairs are facing in terms of this particular matter of capacity, be it resource and as well the infrastructure that we know that it's a challenge in some other areas. So I'm actually noting the positivity and appreciation from you with regards to this process. Honorable Gerik.
Yes, Chair, good morning to you and good morning to the colleagues and the Department of Home Affairs. I'm going to be very brief, wanting to thank the advocate from the department. I simply think the articulation and the clarity suffice, and understanding that no law should be read in isolation. Therefore, we have the Constitution Act guiding us on all the issues that we are dealing with. And I think I will then also propose that we accept the articulation, the clarity, and then we move on. Thank you very much indeed.
Thank you, Honorable Gerik. You are just reminding me of the comment when we started, when you were asking them, don't we have the capacity, legal capacity in the department to deal with these issues? So I'm happy that today you are happy about the articulation and the process that we have undertaken till to date. Honorable
Noe. Maybe they brought in a senior advocate. Thank you.
All right. Honorable Noe.
Thank you, Chair. I also stand on the protocol established. And good morning, honorable members and the department officials. Chair, I just want to add on what Honorable Billy said in terms of taking the process forward based on the comments that we received from public and oral. Perhaps as we have started on the good footing or the right foot, as we move in towards the white paper, I don't know at what time or period that will be shared with us so that we don't get engaged with these documents when it is at the critical time, so that we've got time also to read through so that we can make meaningful inputs. Thank you, Chair.
Thank you, Honorable Noe. I hope the department is taking note of your input that ASAP, as soon as they have a specific date, with regards to that they need to share with us so that we must be ready for the process. Honorable Phala.
Thank you, Chair, and good morning, members, and good morning to the officials. And let me as well appreciate the summarized version of the presentation by the advocate. Mine, Chair, is I'm happy about what my colleagues are saying, and I stand on that position as well. I just have a little bit of a concern to the advocate, which is not in line with what they presented here in terms of the judgment. I want to know whether the department have ever quantified the amount of money we spend on the issues of immigration. This is what I want just clarity from the department. How much do we spend on the immigration challenges? Thank you, Chair.
Thank you, Honorable Phala. Advocate, the question is straight, precise, and forward. If we have a value cost out, like, do we have anything that we can say that specifically in terms of the value and rents? This is how much we spent as the department with regards to immigration. That was one of the questions, and the only thing that I've noted as well is the question from Honorable Noe about the time frame with regards to the process of the white paper. Those were only two questions, but note as well the appreciations from members with regards to where we come from in terms of the roadmap of this bill to date, that we really appreciate the work done as this particular select committee. Over to you, sir.
Now, thank you, Honorable Chair and Honorable members for the questions. I do have my colleagues who are from the branch immigration services in terms of the amount or the value that the department spends in relation to enforcement of immigration laws, be it related to detention or the deportation cost. They would be able to assist me with that. Chair, through you, Chair, of course. The issue maybe that I can provide to the select committee is in relation to the process that we have undertaken and where we are with regard to the development of the white paper. We are now at a stage where we are requesting a cabinet to grant us the approval to publish the white paper for public comments, and I think at that stage, Chair, we should be able, once we have obtained the cabinet approval on the white paper itself, we should then be able to provide the select committee with a copy of the white paper. The reason we are saying so, Chair, is because it is only at the stage when cabinet is satisfied that what we are doing is indeed to the benefit of the Republic of South Africa. It is only at that stage that we can be able to share the documents, because then at least we have the authority and we are comforted that indeed this is what South Africa, from an executive point of view, that they would want the route to take. But we should be able to provide that document at that stage. And what I can indicate, Chair, is that tomorrow we are presenting the white paper to the cabinet committee, so that once we get the approval and support from the cabinet committee, the document will then be served to cabinet itself, where we present, and then cabinet will then provide us with the decision. We cannot anticipate whether we're going to get a yes or no, but we are hopeful that that cabinet will grant us the necessary approval, and then we can go on. Through you, Chair, if I may ask my colleagues from, we have Mrs. Pukanuka from the Branch Immigration Services, if you would be able to just provide that quantification that Honorable Pala has requested. Thank you, Chair.
Thank you, Advocate. Over to your colleague.
Good morning, honorables. With regard to the
please save us. You can switch off your video. Please save us from the TikTok. Thank you. Over to you.
Okay. With regard to the quantification for the costing for the enforcement for deportation.
We are live streaming. Hence, I said to you, can you switch off your video so you can continue, because we want to save yourself and ourselves from TikToking. Over to you. Switch off the video, then continue.
Hello?
Hello. Switch off the video and continue.
On my side, my video is on.
But you are not proper. Just switch off the video and continue.
Okay. Thank you. With regard to the deportation, to the costing, yes, we will be able to provide the costing, but I won't be able to give them by head now. But we can provide the cost for the past financial year and to current for the deportation that took place. Thank you.
Okay, thank you. With regards to that, then what you would do, just after the meeting, can you send a detailed report with regards to those costs? Because, when we have these sessions, the public is following through, the media is following through. We might be asked, and we don't want to say that we'll check or what, but just give us the information just immediately after this meeting through the Secretariat Office of the Select Committee. Thank you. At least we know that we have information that has to deal with the cost with regards to immigration. With that being said, we want to thank the department and our legal team for being with us throughout this process of ensuring that we make sure that this bill comes to light. We thank the department, state law advisor and parliamentary legal advisors, as I said, as well as all the commentators for their engagement on this important bill. The adoption of the bill marks a significant milestone in adhering to the Constitutional Court judgments and providing a fair process to illegal foreigners in respect of their arrest and detention, taking the interest of justice into consideration. We encourage the commentators to follow the department's processes in respect of the white paper on citizenship, immigration, and refugee protection to ensure that the broader comments find expression in that particular bill. With that being said, you are released from Home Affairs and the legal advisor. We have dealt with the item accordingly. Now it will be for members for consideration of the report for adoption as it has been sent. Gershwin, can you flight the agenda and then go straight to the presentation of our overview summary report?
Thank you, Chairperson. Okay, members, before us we have the report of the committee in terms of the Immigration Amendment Bill, Bill 8B 2024, National Assembly Section 75. It was referred to the committee on 11 September 2025. The committee held a briefing with the Minister for Home Affairs on 10 September. And then in terms of our public participation process, we advertised for three weeks. We requested written submissions. The adverts were published in 2 national papers and 9 provincial papers. And in addition, Parliament's sign language interpreter produced a video for publication that was flighted on social media platforms, including the adverts were published on all of Parliament's websites and social media platforms as well. Chairperson, in terms of the responses, we received 16 written submissions, including 8 from individuals and 8 from organizations. We have all the documentation for the responses and the analysis. Public is more than welcome to request this in writing. The committee was encouraged by the youngest participant, Mr. Sitimbiso Lamont, a 15-year-old school learner. Chairperson, the committee consideration today, we put before the committee the report to consider the bill, and we'll leave it over to you, Chairperson, to take us through the voting on the bill. Thank you, Chairperson.
Thank you, Geshwan. Members, I'm now noting hands for consideration of this report. Honorable Phala, Honorable Billy, and Honorable, no, let me note your hand. I can see that you've removed it. It's fine. Honorable Phala?
Thank you, Chair. And thank you, Kesh, for the report. Chair, I'm just concerned about point number 3. If Kesh can just move to that point number 3, please. Yeah, the confirmed publication which are here. I'm a little bit concerned about the publications which are indicated here in the province. As you know, that Limpopo is a multi. There are different ethnic groups there. We've got Space Pedi, we've got Chivenda, we've got Istonga, we've got Sindebele. I'm concerned about this publication which have been used here. For instance, I just checked the one in Spedi, which I'm told it is an insignificant community-based publication based in Malamalela. It is not even known in the broader Norman Mashabane region. This is a concern. If ever there was a publication were done on this, I'll just check on Chivenda and the other languages. I think also we do have Isiswati in the area, and I wonder whether this really covered a larger part of our communities. This is my concern, Chair. Thank you very much.
Thank you, Honorable Phala. I think the concern is noted as a lesson that we need to learn. But you would know these publicators were acquired based on what they have submitted as prices that we were abreast with in terms of how much do they charge. So whoever who has been able to publicize are those who got to be procured through SCM. But we are noting that we would need to explore to other media houses as we do this publication. Honorable Billy?
Chairperson and the honorable members, I move for the adoption of the report.
Thank you, Honorable Billy. Honorable Billy moves for the adoption of the report. Honorable Nonkonyan?
Chair, I rise to thank the Secretariat for very good report, and I consequently move for adoption. Second, Honorable Billy.
Thank you, Honorable Billy and Honorable Nonkonyane for adoption and seconding this report as a true reflection. That makes our work easy so that this report can then go through the NCOP process for adoption. Honorable Billy, you can lower your hand.
No, Chairperson, it's an old hand. I apologize.
Okay, thank you. Yeah, members, with that being said, this meeting has dealt with the item as supposed to, but I want to extend my gratitude and appreciation on behalf of the whole committee to our state legal advisor. We have actually seen that we do have capabilities. We have fit for purpose people in our department. We want to thank you, Advocate Dakshan Kasan, for being with us till to date, where as members we have adopted the report. And we thank the department, and we hope that the department will be consistent as we'll be dealing with other issues that needs the department attention. And members, we all have noted that in today's meeting, it was all about our business, not making an excuse for the minister and deputy minister for not joining. But we know today we really needed those who have been with us, like Advocate Malakate and his colleagues. We'll just await the response with regards to cost implications on immigrations that will be sent through our office. The meeting stand adjourned on this first item. We will indicate members as soon as we get highlights from the side of the minister and deputy minister on their availability, because I have indicated that they have joined the cabinet, but they will indicate to us on when can they be excused and join this meeting for the item before us of the magistrates remuneration. Yes.
Apologies, Chair. I really apologize. I couldn't lift my hand in time. Honourable Nell is on the platform, Chair. Thank you.
Chairperson, very, very good morning. Now, I can confirm virtually in person that I have left the Cabinet Committee and I am ready. And I think there's an indication that the Minister might join as well as soon as she can leave the Cabinet Committee. But very good morning to yourself and to all of the members and the officials. Thank you.
Okay, thank you. We thank you for being proactive, because I think you understand our hesitation with regards to the matter before us. Without wasting time, one would want to start the next session, but let me just deal with administration issues of releasing those who've been with us for the first item before we can engage with the item before us. Those who've been with us for the first item, can you be excused? And then if you feel that you would still want to continue with the session, it's fine. You are welcome, because as Parliament, we know that we are Parliament of the people. Whatever that we do, it's representing people's interest. So if you still feel that you can join us for the next session, it's fine. But if you have other commitment, you are officially released for the first item.
Chair, you're silent.
I'm silent because I'm still waiting for people to leave the meeting. They're still leaving the meeting. So on my side, I'm taking note that they are actually leaving the meeting. I would start immediately as they finish. Gesh, can you flight the agenda before us? Thank you, Gesh. Honorable members, Honorable Deputy Minister and your collective, This briefing by the Minister for Justice and Constitutional Development on the current state of engagement with magistrates to address the concerns they have raised in relation to the remuneration benefits, working condition at courts and safety of magistrates. Deputy Minister, I think you know that as this select committee, this was one of the first items that we dealt with under your department. On the 29th of October 2025, the committee hosted a meeting with the Independent Commission for the Remuneration of Public Office Bearers on the Consolidated Remuneration Review Report for 2024 and the recommendation in the report. The Commission advised that it must finalize consultations and then submit the report to the President. The Commission further said the committee noted that the committee had representative from the Judicial Officers Association of South Africa and the Association of Regional Magistrates of Southern Africa to observe the proceedings. Today's meeting has been called to specifically look at the safety and working condition of magistrate and staff at magistrate courts, given the protest action that took place in Durban last month. Honorable Billy, who represents KZN province, raised this matter with the committee and requested that we host a meeting. And as well, Honorable Nonkonyane was in conversation timelessly asking us, when are we bringing you before the committee so that you can respond to this issue, because it's an agent matter. In addition as well, Honorable Gotzel, who represents the Western Cape province, has also raised concerns regarding the safety of a magistrate who was threatened by an accused person at a place of residence. It is important also to note that during the recent oversight visit to the Free State province, the committee raised concerns regarding X-ray machines in courts that are not working and the potential security risk that this poses. We are pleased that your presentation covers infrastructural challenges and we look forward to the presentation and the input today that covers all the issues that has been raised before your office. Over to you, DM, and as well indicate who you have with you as your collective so that we take note that indeed the department is taking us serious, bringing relevant people that will be able to respond to issues raised by members. Over to you, DM.
Okay. Put my hand up.
Honorable Billy? Yes.
So can you hear me?
Yes, I can hear you.
Sorry, I'm just struggling with my network.
I can hear you. You can switch off your video so that at least the network doesn't compete with your connectivity.
Thank you, Chair. Chair, just before the DM comes in, I just want to raise my concern. You are quite correct to say that I had initiated this and I had deliberately called upon the minister to be here in Parliament so that she could get an opportunity to clarify Parliament as to what is going on. Now, with the greatest respect to the DM and having full appreciation that the DM is delegated by the minister to deal with issues of the magistrates, I find it very unfortunate, Chairperson, and frankly unacceptable, because this meeting has got a huge public interest. People that are affected by this were hoping to see and hear what the minister's got to say, because the reality and the truth is the buck stops at the minister's door. Now, this is for the second time that the minister has failed to appear before this committee to account on a matter as urgent and serious as the plight of our South African magistrates. Chairperson, I raised with you in the past few weeks that in Durban and across the country, the magistrates took to the streets in frustration over the collapsing working conditions, but more importantly, also the safety of our courts and the salary delays. Now, we as Parliament have done our part and we acted. We summoned the minister precisely because of this situation and it reaching this point that it has reached. And Chairperson, yet again, we are met with an empty chair. And to be quite honest, I think, Chairperson, this continued absence by the minister is not just disrespectful to this committee, but I want to put it to you, Chairperson, that this is a direct insult to the magistrates who uphold justice every day under very difficult and impossible conditions. It goes on to show, Chairperson, the disturbing lack of urgency, empathy, and leadership from the executive authority responsible for their well-being. Now, Chairperson, I don't think the minister can come and account to Parliament in a way that is optional. Accountability can be optional. When the magistrate's safety is threatened, when our courts are uninhabitable, and when the remuneration process is...
Honorable Billy, we're noting the concern, but I think you are repeating what has been said on the opening remarks.
Can I just conclude?
Yes, but I'm just saying, I'm just cautioning on your repetition, noting your concern, and one would want to respond as the chairperson. Thank you. Over to you.
I think you could have allowed me to complete as I'm about to conclude. I think you and I are equally frustrated and concerned about this, otherwise we would not be dealing with it. I want to formally request, Chairperson, that this committee formally records its dissatisfaction and that the minister be required to appear at the earliest possible date because, as I've said, the buck stopped at her door. She needs to deal with this. She can't run away from this. I submit, Chair.
Thank you, Honorable Billy. I think one would want to just indicate to you that we do note your frustration. However, you must note that in the absence of the minister... Honorable Nonkonyane, over to you. I didn't see your hand. You didn't even indicate. Over to you.
Oh, it is there.
Okay.
Chair, I just want to respect you so that you have got a last say on this matter. First of all, Chair, I would like to request Honorable Billy to withdraw the insinuation against the minister. I'm saying so because at the very beginning, we were alerted that today is a cabinet committee. All of us in this platform know that on Wednesday there is always a cabinet, and you clearly indicated that and conveyed to us that the minister and the deputy minister said that they will try their best to come with us. And indeed, the deputy minister, who has been delegated by the minister, is here. And with respect, I don't think that it is justifiable for the honourable member to really cast aspersion against the minister, who has actually shown respect to this committee through you. And above all, when you presented this to us, we accepted the apology. And now we cannot therefore revert to that. Hence, I'm of the view then that let us then proceed and we have been throughout accepting the deputy ministers, especially when they are delegated, to be accorded a hearing. I will therefore, Chair, respectfully request that let us proceed and plead with Honourable Billy really not to insist that we must postpone this matter for the minister to come. As we all know, we don't have a luxury of time. Thank you, Chair.
Thank you, Honorable Nonkonyane. I'm noting your intervention with regards to what Honorable Billy could have said. And one agrees that there's no way that we will be postponing the session. We're going to continue according to how it has been planned. Honorable members, you will all know, in the absence of the minister, we always have the presence of the DM, and the DM will lead the delegation. Whatever that is happening today is not for the first time that you get only with this department that you have the deputy minister being delegated by the minister. So I'm not sure who is speaking.
It's Virgil Harriger. Sorry to interrupt. My hand is up for quite some time.
Okay, I haven't seen your hand. Honorable Harriger, over to you.
Yeah, Chair, mine is going to be brief again. I just want to understand there's no objection against the presence of the deputy minister since there's a cabinet meeting today. Although we have touched on this previously by saying if it's important matter and the cabinet is engaged, that does then defer the items to another date. However, if the deputy minister has been delegated by the minister, together with the delegation, there's some powers. I just want to understand the rollout, because this matter is serious, it's urgent, and it must be dealt with urgently. But I just want to understand, after today's meeting, if there's any resolve, will there be a timeline in terms of the implementation of any decision that we need to get from the deputy minister, and where else does this need to go in order to conclude on it, in order to finalize the matter? This is the issue here, Chairperson. In other words, if there's timelines and the department can commit to timelines, we can then also, communicate via our media channels to the magistrates and so on, and to the courts, that we have concluded as a select committee, and we will await the outcome of the Department of Justice and Constitutional Development. Thank you, Chairperson.
Thank you, Honorable Kherik. I think what you are suggesting is that let's give the opportunity to the DM, so we engage on the matter, and then your issues will be responded to accordingly. And members, I want to caution you, there's no suggestion that that meeting is not sitting. Honorable Billy, I've never spoken on the issue of postponing the meeting. I think his matter is something else that has to do with the presence of the minister, of which one is noting that the DM has been delegated by the minister. As usual, as we normally process our meetings, we are going to do the very same process of allowing the DM to lead the department as delegated. And then we'll engage based on issues that are before us. I think what we need to avoid is playing the man, but play the game. The DM is here, is going to continue with his opening remarks and political remarks, and we'll get the presentation, and then after, we'll then need to engage based on the commitment and undertakings before us. Because we all know this issue is a serious matter. As I've indicated, this is one of the issues that we have dealt with before as this select committee. When we started, it was one of the issues we dealt with in the department. And all of us, we have committed ourselves to dealing with this matter, to the entire process up until we get the outcomes that all of us we would want to achieve for our magistrate. So let's not go up and down and deal with issues that we think that they are not even worth discussing them in this particular meeting. I would want to, as I officially opened this meeting, I want to now hand over to the Deputy Minister to lead the delegation and continue with his opening remarks with regards to the item before us. Over to you, DM.
Okay, Chairperson, thank you very, very much. And again, my greetings to all honourable members.
Who is saying Chairperson? Honourable Billy?
Yes, Chairperson. Just Chairperson, with the greatest respect, I would like to register my objection to the apology of the Minister.
No, it will be noted, don't worry. Over to you, Honourable DM.
Okay. No, thank you very, very much, Chairperson, and thank you to all honourable members and officials on the platform. for inviting us to discuss a matter that are very, very fundamental to the safeguarding and the building and strengthening of our constitutional democracy. I'm joined by the Deputy Director General Court Services, Mr. Charles Mohalaba, and Deputy Director General Tabiso Titi. Together they will assist me in making this presentation. I'll outline just now the areas that we will cover respectively. I'm also joined by Advocate Blendon Williams, who's the head of my office, and Ms. Zoleka Ndundane, who's our parliamentary liaison officer. There are other officials from the department. I see, my apologies. I see the acting Director General, Ms. Kale Pillay, is also present here. So I think the department is quite well represented at a very, very high level, also befitting the importance of this issue. Maybe before I proceed to the substance of the presentation, it would be apposite in legal language to address maybe one or two points in limine, so to speak. I think first of all, if we turn to the Constitution and the section that deals with executive authority of the Republic, it makes it clear that the President appoints both ministers and deputy ministers. The function of deputy ministers is to assist ministers. It's not dealt with in the Constitution, but the practice has developed where after the appointment of ministers and deputy ministers, the President requires the ministers and the deputy ministers together to agree on a division of labor, which is then captured in a formal document delegating powers from the minister to the deputy minister. That document is signed by both the minister and the deputy minister, and it's lodged with the President. See, if there's any variation to those delegations, it must be signed again by both the minister and the deputy minister, and it must be submitted to the President. So I just wanted to clarify that in respect of magistrates, both the representation on the Magistrates Commission, engaging with fora such as the Regional Court Presidents Forum and the Chief Magistrates Forum, and the appointment of acting magistrates, those are all matters that the minister has delegated to me. So it's not a question of her delegating me to attend this meeting. She has delegated those powers and functions to me as the deputy minister, and I exercise them on an ongoing basis. So, in fact, the issue that is before the committee is an issue that is my responsibility, and therefore, as the members have said, the ultimate authority on these matters still remains with the minister as the executive authority, but on a day-to-day basis, they are the issues that I deal with. So I think, therefore, in respect of any matters that would require follow-up out of this discussion, the Deputy Minister, would be the one who would be responsible for taking that forward together with the relevant officials in the department. The second issue that I just want to deal with very quickly is the apology that was tendered by the Minister and I in respect to the meeting of the 29th. I don't want to belabor the point, but I was unable to attend this meeting because I was addressing the 30th anniversary of the South African Human Rights Commission, a respected and key Chapter 9 institution created by our Constitution, which had invited me some 6 weeks prior. I think the invitation was dated the 18th of September. If my recollection is correct, the the invitation to attend the meeting of the 29th was issued, I think, a week and a few days prior. I think it was, if I recall correctly, the 18th for the 29th. Or something like that. So I think members would accept that having confirmed an invitation some 6 weeks or 5 weeks before the invitation, it did present some very real challenges to not honor that invitation, especially coming from a Chapter 9 institution, which in terms of Section 181(3) of the Constitution, we are duty-bound to support through legislative and other means. The minister was unable to attend because she was co-chairing, if I could remember correctly, with the Minister of Public Service and Administration, the G20 anti-corruption forum or summit. Now, I think members would appreciate that given the serious nature of the challenges that we face with corruption in our country and the way that it has tarnished the image of the country, it would indeed have been very, very problematic for South Africa to be hosting an anti-corruption forum without the presence of the Minister of Justice and Constitutional Development. So I think there's no disrespect that was intended to the committee. I think we've always honored invitations and requests by the committee, but I think it would have been very, very difficult for us to have not honored those other obligations. I think I want to just conclude on this matter by really making an appeal to members to say that we are all, first and foremost, regardless of whatever other positions we occupy, we are elected representatives of our people. When our people go and vote and elect us to represent them, they are entrusting us with their hopes and aspirations for a better life and the realization of the vision of the Constitution. And I think the way that we conduct ourselves and talk about each other, we do need to exercise some caution and moderation, because ultimately, in the eyes of the people, the diminishing the stature, the standing of any public representative ultimately diminishes the standing of all of us. It's a little bit like a family where parents fight and insult and say bad things about each other in front of the children, thinking that they will increase their own stature in the eyes of the children. But all that happens is that the stature of both parents go down in the eyes of the children. So I think it's just an appeal that we do treat each other with some degree of respect. On then to the presentation, if it could be projected. I'm not sure is the projection? Ah, there we go. Thank you very, very much. Okay. If we could maybe move it into presentation mode and go to slide 2. Okay. I'm not going to read that. I think it just states the invitation and the purpose of the invitation. But I do want there just to make a preliminary point, which I will come back to and deal with in more detail in the course of the presentation. And that is that I do think as we go about our work, both in the executive and in the legislature, we always need to come back to the Constitution, the basic principles and provisions of the Constitution, and of the applicable law that's passed in terms of that Constitution. And I think I just want to say at the outset that we must be very, very careful to recognize that the judiciary is a separate and independent arm of the state. And in how we talk about that arm of state and deal with the issues and the challenges that it faces, we must never, ever forget that fundamental underlying principle. So I just want to make it, I'll address this in my nice high legal language later on, but I just want to say in plain language that magistrates are not employees of the Department of Justice and Constitutional Development. That was the case under apartheid. Magistrates were civil servants. They were employees of the Department of Justice. They were officials like any other official. They were remunerated in terms of the way that civil servants are remunerated. They could be hired and fired, and they could be posted anywhere in the country, as civil servants could be. Now, subsequently, in terms of both the Constitution and the jurisprudence established by our courts, most notably in the Van Rooyen judgment, it's very clear that magistrates are judicial officers. They belong to the judiciary. We still sit with the challenge of a bifurcated or a split judiciary with the so-called higher or superior courts and the lower or inferior courts. Those are terminologies which I try to avoid as far as possible, because I think we are moving towards a single judiciary. But the point is, these are judicial officers. They're not employees of the department. And I don't think we should create, wittingly or unwittingly, the situation, the impression that we are somehow in a bargaining or negotiating process or position in respect of people who are independent, and in respect of which the Constitution creates structures to deal with issues of remuneration, of conditions of employment. Yes, we are at a stage in our constitutional development where the Department of Justice still provides a lot of the administrative support to the magistracy. It's something that we're moving away from, and I'll conclude the presentation on that. If we could move to slide 3, that is really the areas that we will be covering today. I will deal with items 1 to 6, and then again from 12 to 16, and I will ask the acting DG, DDG Mohalaba and DDG Titi, to deal with items 7 through to 11 of the presentation. If we can then turn to slide 4. Slide 4, please. Yes. Okay. I think the starting point, as I said, must be the Constitution. And Section 34 of the Constitution, I'm not going to read every word. I think members have the presentation and it is projected on the screen, and I'm sure that members also have their own copies of the Constitution. But in terms of Section 34, which really is a very fundamental clause of the Constitution, which also speaks to the moving words of the preamble to the Constitution, it says that everyone has the right to have a dispute that can be resolved by the application of law decided in a fair, public hearing before a court, or where appropriate, another independent and impartial tribunal or forum. Section 165 then goes on to outline the founding and basic principles that apply to the judiciary, that the judicial authority of the Republic is vested in the courts, that the courts are independent and subject only to the Constitution and the law. And I want to pause on the 4th item, because I think it speaks directly to what we are going to deal with today. And that is that organs of state, through legislative and other means, must assist and protect the courts to ensure the independence, the impartiality, dignity, accessibility, and effectiveness of the courts. Now, it says that those organs of state, including the executive, must assist and protect, but at the same time giving recognition to the fact that the judiciary is an independent, a fully independent arm of the state. And then very importantly, in point 5, that it's the Chief Justice who is the head of the judiciary and exercises responsibility over the establishment of the monitoring and the norms and standards and the exercise of judicial functions. And I think members would recall that yesterday it was the Chief Justice who was presenting the judiciary report to the nation, outlining in very comprehensively and in great detail the statistics, the functioning, and other dynamics in the judiciary. Slide 5, please. Now, Section 166 of the Constitution provides that in terms of the judicial system, the courts include the magistrates' courts, and in terms of 170 of the Constitution, magistrates' courts and all other courts may decide any matter determined by an Act of Parliament, but that the courts below that of a High Court may not inquire into constitutionality. Section 177 talks about the criteria for appointment. I'm not going to dwell upon that. If we can go to slide 6. I think this starts then getting closer to the issues that the committee has asked us to address. In terms of the Magistrates Act, Section 11 provides that subject to the provisions of this act, the conditions of service of a magistrate shall be determined in accordance with the regulations in terms of Section 16. Section 12 goes on to say that magistrates are entitled to salaries and allowances or benefits that will be determined by the President from time to time in a notice of the Gazette, taking into consideration the recommendations of the Independent Commission, which this committee interacted with at its last meeting on the 29th, and approved by Parliament. I think it's important because, again, it just emphasizes the point that these magistrates are not employees of the department. There's no scope in the Constitution, in the law, for us to be sitting and negotiating and bargaining salaries, allowances, or benefits. It would be improper, it would be unlawful and unconstitutional for us to be doing that. And I think it's a point that we really, really need to be very, very clear on. The key role players here are the President and Parliament. The Act does, Section 12 does provide that when the Commission referred to above, when investigating and in considering the remuneration of magistrates, must consult, but it's the Commission that must consult with the Minister of Justice and Constitutional Development and the Cabinet member responsible for finance and the Chief Justice or a person designated by the Chief Justice. So it's not the Minister engaging, consulting, bargaining, negotiating with the magistrates. The Minister is consulted by the Independent Commission. If we can turn to page 7. Now, before I proceed dealing with section 16.1, I just want to point out that the Minister of Justice and Constitutional Development has, on the 19th of November of this year, written to the Honourable Judge President Karelse, who's the chairperson of the Independent Commission on Remuneration of Public Office Bearers, requesting that the Independent Commission engages in consultation with the Judicial Officers Association of South Africa and the Association of Regional Court Magistrates, JOASA and ARAMSA. Again, that is consistent with the provisions of the Constitution and the law, that it's not the Minister that does that engagement. The Minister was urging, requesting, suggesting to the Independent Commission that they have a meaningful engagement with these organizations. Now, we then go to the regulations that deal with the conditions of employment, tools of trade, and those matters. So section 16.1 of the Magistrates Act provides that the minister, right here, the minister does have power, but that power comes in after the Magistrates Commission has made recommendations. The minister is then empowered to make regulation in relation to the judicial officers of the lower courts regarding the matters that are listed there. And those would include transfer and resettlement, leave gratuity, pension contribution, procedures for dealing with complaints, and finally, and I think quite relevant, also the recognition of any professional society. So, but as I said, the key point there is that the minister makes those regulations after the Magistrates Commission has made a recommendation, and I'll come back to why that is relevant. Slide 8. I think just in relation to the question by the committee as to what engagements are taking place, and also the point raised earlier about whether I'm the appropriate and qualified person to be talking about these things. So the minister has delegated matters regarding the magistracy to the deputy minister. The deputy minister and relevant officials, senior officials from the department, we meet on an ongoing basis with the leadership of regional and district magistrates, at the very least on a quarterly basis. I think ever since I've been appointed and delegated this responsibility, I can't recall, I think maybe with one exception, ever not attending those meetings. There are some challenges which we've urged the two bodies, the Regional Court Presidents Forum and the Magistrates Commission, to resolve in terms of how they schedule meetings, which causes some challenges for myself and the officials in the department. But at our last meeting, which was like a week or ago, they had agreed that they were going to give attention to those matters. The Regional Court Presidents Forum is the 9 regional court presidents, 1 per province. Chief Magistrates Forum is currently consists of 19 chief magistrates, including some who are acting. Myself and the chair of the Magistrates Commission have agreed that wherever possible, we will attend these meetings at the same time, because very often the issues that are relevant to the department are also relevant to the Magistrates Commission, just in an attempt to streamline and make things more effective and efficient and expeditious. Furthermore, the Deputy Minister represents the Minister at the Magistrates Commission. And I use that slot also to brief the commission, which I think a number of members of the NCOP would also serve on policy and legislative matters. And then we have a team led by the Director General or the Acting Director General, who then engage the commission on more administrative matters. We can go to slide 9. Now, again, I'm not going to read that word for word, but I think it just amplifies what I said earlier about the process that is followed in the determination of the remuneration of magistrates. So, I mean, those matters fall within the ambit of the independent commission, who then makes recommendations to the president, comes to Parliament as well. The minister does have an important role to be consulted on those recommendations, but is not part of the formulation of the recommendations themselves. I think in paragraph 5.3, it makes the point that really, in terms of section 12.2 of the Magistrates Act, really the way things are structured is that there is provision almost for a regular annual determination of the salaries, so that they can also keep up with the changing conditions. If we can go then to slide 10. Okay. Just speaking to the point I made earlier about the history of the magistracy in South Africa. In apartheid South Africa, magistrates, as I said, were civil servants, and they were treated as such. Accordingly, magistrates were included in the Department of Justice and Constitutional Development's financial instructions. But giving recognition to the fact that the judiciary, that the magistrates belong to the judicial arm of the state, we felt it's highly inappropriate for them to be covered in a financial instruction manual that deals with the public service and the operations of the public service. And that's why we then moved those provisions relating to magistrates out and put them into a separate document dealing with and it's called a financial policy for judicial officers. And it's really meant to enhance the independence of the magistracy. We think that in the fullness of time, as we advance in this process of creating a single judiciary and a judiciary-led court administration, the ideal would finally be for the Office of the Chief Justice to have financial instructions that apply specifically to the magistracy, that it be done by the Office of the Chief Justice. At the moment, it's not possible because the expenses related to the magistracy still come from the vote account of the Department of Justice and Constitutional Development. And so it's accepted that these financial instructions still have to be issued by the DG of Justice as the accounting officer. Those things can only happen in terms of Section 16 on the recommendation of the Magistrates Commission. So I make that point because I'm not sure whether Joasa Aramsa raised this, but I'm sure that especially the regional court presidents might, if they engage with the committee, might raise the issue of, for example, a transversal contract relating to the procurement of cell phones and data and things like that, where there's a bit of a difference of opinion between the regional courts presidents and the chief magistrates. But ultimately, we did the correct thing by taking that manual, those instructions, including this transversal contract issue. It was taken to the Magistrates Commission. It was the Magistrates Commission ultimately that took the decision, and based on that, the DG then issued these financial instructions. I think the point is also made that this financial policy for judicial officers has also really introduced new things such as reimbursement of magistrates for the acquisition of their robes and other related matters. If we can go to slide 11, the manual also deals with issues of subsistence and travel and catering and hiring of venues and farewell functions, acquisition of robes, mobile communication, and asset management. Then can we go to slide 12, where I will hand over the baton first to the acting DG if she wishes to make any introductory remarks, and then Chair, through you, the DDG Mohalaba and DDG Titi. But I just want to make the preliminary remarks on the issue of the state of security, is that we as the department, we regard this as an extremely, extremely serious matter, because it goes to the very, very heart of protecting our constitutional democracy. Because if that judicial arm of the state does not have the safety, the security, the peace of mind to exercise its constitutional power of hearing and deciding on matters without fear or favor or prejudice, it's a direct assault on our constitutional democracy. And it becomes a matter that's not just a justice matter, but it becomes a broader matter of national security. And that's why we take it so seriously. I just want to say personally, I have been focused very much on the challenges in the Western Cape. I have visited a number of the courts where there have been shooting incidents. And I have, together with the Judge President of the Western Cape, Judge Mabindla Bokwana, and other judges, visited those courts. We have also facilitated meetings between the Judge President and the Minister and Deputy Ministers of Police. They have already started acting in terms of raising the profile of visible policing around our courts. We have also engaged with the Minister of Police on the issues of gang violence in the Western Cape, gang violence and organized crime more broadly. And I'm not going to go into too much detail on that. It's maybe something that we can come back to the committee at a later stage. But the issue that concerns us particularly is that it seems to be beyond any shadow of a doubt that there's a very real nexus between gang activity in the community and gang activity in the prisons, in our correctional facilities. And what is concerning for us as justice is that that nexus seems to be running through our courts, because that is where remand detainees come from prisons, are able to convey messages very often to foot soldiers on the ground in the community to eliminate either rival gangs or law enforcement officials, or sadly, even judicial officers. And on the other hand, to be bringing contraband and other things back. And that exchange happens very often in the holding cells of our courts. And that's for that reason that we've also raised that matter very, very sharply with the Minister of Police, to say that we need to tighten up the quality of deployment of court orderlies and the command and control structure that is responsible for those court orderlies, because that in many ways is a weak link in the chain. What we are also doing very, very actively is pursuing the use of technological methods to obviate the need for moving those remand detainees physically from correctional facilities to our courts. I again had an engagement with the Judge President of the Western Cape and Judge Erasmus at the Goodwood Correctional Facility, where there is a branch where there's a high court in that facility. So many of the hearings can be held there in the court without the need to move those remand detainees. But maybe at this juncture, Chairperson, through you, let me hand over to the acting DG and then the relevant DDGs to cover this area of the presentation.
Thank you very much, Deputy Minister, and good morning to the Honourable Chairperson and Honourable members. And I think, let me hand over to DDG Moalabo and DDG Titi, as they are the ones leading this process in terms of facilities, security, etc. I'm not sure who's going first, but may I hand over to them, Chairperson. Thank you very much.
Thank you. I just want to highlight to those who will be speaking before us that it is important to firstly switch on actually your video so we can see you. And then if you have technical glitches with your video, you can then switch off the video but continue with the presentation. Over to you, DDG.
Thanks, Chair, Deputy Minister and Minister. I don't know if my picture is visible on your side, Chair.
You are proper and visible, but if you have challenges with connectivity, you can switch off your video. So
no, thanks. You will indicate, Chair. Thanks a lot. Morning, Chair again, Deputy Minister, members of the committee. My name is Thabiso Titi. My responsibilities include, amongst others, security facilities in the department. I think DM has properly and adequately characterized the state of security and insecurity in our facilities. I will only zoom into what we are currently dealing with as a response mechanism to the challenges that we are encountering in terms of the heightened threats to the members of the judiciary. We have identified a number of threats that, amongst others, the violent attacks, threats of kidnapping, anonymous calling, and death threats that are meted at the members of the judiciary. What we have done is to expand our services to include the close protection as part of our contract as a department, to ensure that should the need arise, we will then be able to provide the members of the judiciary with 3 types of protection. The first one will be close protection, and the other one will be as they are in transit protection, and the last one will be the static protection that is going to be at their place of residence. What we have done as a department is to develop a procedure that is aiming to help us to manage this thing quickly, because they happen at the court level, which are managed by the provinces. So we have advised the provincial security managers, as and when the incidents are reported, that they escalate it to us. Number one, for us to develop a quicker intervention, but they equally go to the nearest police station to make the police aware of it. And as another process, they go interact with the members of the judiciary to get the written statements. But we also do a threat and risk assessment so that we can be able to determine the level of the threat and the interventions that we need to put in place in ensuring that we respond adequately to the threat that has been reported. We also interact with the other security agencies in dealing with some of these threats. And I think DM mentioned the collaboration with the other cluster departments. We have established a court security management committee that is dealing with this thing on a daily basis. But over a period of time, we also do a review of the threats. Should the threat still persist, we'll continue with the protection, but should the threat be assessed as lower, we'll then reconsider a phased out approach in terms of how we scale down on the protection of the judiciary. Can you go to the next slide? However, as a department, we have taken the initiative as well, Chair, members of the Portfolio Committee, to continue to engage with the security awareness campaigns at various levels of the judiciary to ensure that they are aware of the security around themselves. And we have produced booklets, and where possible, we have done security briefings to make them aware of the environment. And this is mainly initiated as a result of an assessment of what would be the risk that we would have seen based on the number of cases that we are profiling in various courts, to make sure that from time to time we look at any possible heightened risk or reduced risk. We continuously do this risk assessment, and we have profiled a number of courts from high, medium to low, where we ensure that we respond adequately, and we continuously report from the court and our provinces to monitor and ensure that we don't find any blind spots in our security-related matters. We, as I've spoken about the services that you have provided here, but one of the things that I need to bring to the attention of the committee is that we have a 24-hour turnaround intervention, where we ensure that as soon as the risk or the threat is reported, we don't wait for the whole value chain of assessment to be put in place. We quickly put the whole assessment, because we don't want to wait for days for the assessment to be completed while our judiciary is at risk. So we have taken that approach of an immediate intervention. To date, in terms of what we've done in the previous year, there were 39 threats that were reported by the magistrates, and then 12 of them were direct threats, and then we managed to put protection for that. However, the other ones that were identified, we have done an assessment, activated, and the protection for 2 magistrates were disapproved because there was no direct threat that was detected, and the 4 of them, we could not activate them, as the direct threat of life of the magistrate could not be justifiable for us. However, we have put interim measures while we're still assessing the threat, as sometimes we find that the threat might not be plausible on the immediate. However, during the appearances and the number of high-profile cases, we have to go back and revisit it to ensure that the judiciary is adequately protected. Can you go to the next one? I want to highlight some of this thing, even though the DM has touched on them, Chair, that we are well aware and appreciate the fact that we have to have a constant appreciation of the risk of the members of the judiciary, and we have to ensure that from time to time we are ready to deploy to ensure that there is sufficient security. One of the challenges that we are dealing with is the insufficient budget to deal with this. However, we have managed as a department to utilize one of the savings in one of the line items to assist us to deal with this. However, we have made some submissions for a review of the security budget to ensure that we have adequate security budget to cover some of these operations. And we have developed a profiling dashboard where we review the threats of the judiciary from time to time, and if there's an increase, we move it to the high level. If there's a decrease, we do an assessment of whether it can be medium or too low, and it goes vice versa. But we do that periodic review of the threats based on the number of courts and as and when we receive the threats from the members of the judiciary. Can go to the next one. Chair and honorable members of the committee, we are aware of the conditions that the members of the judiciary are confronted with in most of our courts. But we need to put it up front for you to know that some of these court infrastructure that we're dealing with are old, and some of them were not originally designed as courts. However, we have managed to convert some of them as in when the need arises to have additional courts. And this in itself present a number of challenges in terms of the conditions assessment that we've done to look in terms of the habitability of these courts. However, I need to put it up front that we are working closely with DPWI to make sure that we look in terms of the process of doing a periodic condition assessment of these courts so that we can be able to make a determination of what are the required interventions. We have done this condition assessment on most of our courts, and then we have made a determination of a need of 4 billion rands that is required to make sure that we bring them to the habitable state as per the OHS standards. Can go to the next one. I think it's important that I put to the committee an appreciation of our budget allocation so that they can be able to understand, the committee can be able to understand where we are operating and what are the challenges financially. Currently, we were allocated 1.5 on the CAPEX, and we are sitting with a required 4.2 over the MTF. And this in itself, it shows that there's a serious deficit. We have seen a serious 29.9% decrease of our allocation that is signaling a drastic reduction for our facility management, and we have raised our concern with Treasury on this thing. This consistent reduction does not only affect the infrastructure project, but overall the maintenance, repairs and refurbishment, and the operational efficiencies of our courts. And you go to the next slide. The challenges that I would want to bring here is that we have 2 programs that are very critical in terms of assisting us to deal with the upkeeping of our courts. We have a day-to-day maintenance where from time to time the court at the court manager level would identify the gaps and they will deal with it. And this program is not necessarily planned because it's as and when issues such as the blocked drains, the blocked toilets and the broken windows, air cons and the others have to be replaced. The second one is what we look at, a planned minor capital works, where we look in terms of an assessment at the end of the year and what we plan to be the major or on the minor capital works, where we deal with issues such as the reconfigurations, replacement of certain matters in courts, and also we look at the damaged parts and issues such as backup power and water supply, because these are issues that affect the operational functioning of the courts. And I need to make a point, we can go to the next slide. I need to make a point that for both the day-to-day maintenance and the minor capital works, they use the same budget of 1 million threshold. And I need to put it up front that the budget that has been allocated for 2024-25 was 49,180,000, and then for which, if we look at it, was inadequate taking into account our 748 courts. In terms of 2025-2026, we have been allocated 51 million, and to date we have spent 36 million, and it's a clear sign that with time we will be having a serious financial shortfall in terms of doing the proper infrastructure maintenance in our courts. Next slide. I need to talk to the bigger program, which is the plane maintenance. and I've already touched on the issues of the budget. That what I would want to raise here, Chair, it's a point that we have a serious challenge in terms of the time frames, the project management, and the delays that are there in terms of our collaboration with the DPWI. Currently, we have 12 projects that are under constructions, and 78 of them are still under planning. And as I've talked about the budget, you can see that the shortfall that we are going to face is the one that is going to make us not to achieve the majority of the challenges that we would want to address with our broader day-to-day maintenance, broader plan maintenance, and the R&R to make our courts habitable. Can go to the next slide. As part of dealing with some of these operations, there are two critical issues that are always a challenge, Chair. One is the alternative water supply, because some of the municipalities had gone into either refurbishing their water pipelines, or they're having a much more water reduction programs that seems to affect our courts. So we have developed a program where we have purchased the water tankers and also drilling of boreholes in certain areas to make sure that there's sufficient water to ensure business continuity. However, we have identified this to go through only the rural areas, but we are recently seeing the challenge coming into the urban areas, and we'll be looking in terms of the discussion with DPWI on what then becomes the best approach to address this from what are the urban courts. The other part in the next slide is the alternative power supply. We have seen that although load shedding is no longer there, there are periodic electricity or power challenges in some of the areas that is affecting our courts. What we have done, we have entered into a program where we are installing generators, inverters, solar panels at most of our facilities. The DOJ, as apart from DPWI, we have implemented the inverters and solar system to address this challenge, even though it's not adequate. The DPWI was handed over the project of the generators because the generators and the solars had to be separated because of the required energy capacity that could be procured by us as a department and the bigger one that needed to be procured by DPWI. However, the DPWI is facing procurement challenges. And in the past 18 months, the program of the generators has moved back from department to IDT and the IDT back to the department. In the meeting that we had last week with the department through our national task team that deals with the periodic interaction on the facilities, we brought to them the point that we cannot afford any more delays on this because this is affecting service delivery. Now, what they had said they would do, they'll go back and look in terms of what are the challenges, but they will ensure that by the end of the financial, they've rolled out this project because we see it as a very critical one to ensure business continuity in our courts. Next one, Chair. If they can allow. I think that from our part, we are done as facilities. I'll hand over to DDG Mahalava to talk about the issues of ICT and the tools of trade. Thanks, Chair.
Good morning, Chairperson and members. Can I confirm if members can see me?
Yes, we can see you. You're in order. You can continue.
Thank you very much, Chairperson, for the opportunity. The issues, Chair, around ICT, we thought it was quite important to reflect the current capacity that we have in relation to the court recording technology, which is the court recording machines that we have. I think Chair and members will see that for the the court recording technology, currently we have about 2,185 total number of CRT machines. And out of that number, we have about 2,037 that are functional. The 148 are not functional, Chair. And there are plans in place which are going to relate to the committee to replace and fix the non-functional CRT machine, which in the main, Chair, does contribute to, in some courts where you have non-functional CRT machines, the matters will therefore be postponed, and it does have an impact in the administration of justice where matters are postponed due to the non-availability of the court recording machines. This also includes the sexual offences system, which is commonly referred to as the SOS, where currently we have about 410 and about 345 are functional. And of course, the impact is the same, Chair, and this would in essence affect the vulnerable persons who have been abused in terms of sexual offences. And again, here, the department does have plans in place to deal with that. We have appeared before the portfolio committee of the correctional services, where the issues that relates to the remand detainees, as well as the high number of remand detainees in the various correctional centres across the country, was a point of discussion. And one of the matters that arose is the AVR, which is the system that is connected to the various courts and to the various correctional centres across the country. We have about 51 of those, and 37 of those are functional, and about 14 of those are not functional. Chair, and as far as the CRTs and the SOS machines, the department has made an application for CARA for funding of these machines, and the application is currently undergoing the necessary consideration by the ministers, and we're quite confident that Cabinet should be able to consider this application. And as soon as the application is approved, we should be able then to replace the CRTs, which are non-functional, as well as the SOS machines that are non-functional in the next financial year, possibly in the second quarter of the next financial year. And of course, the AVR, we have agreed with the Department of Correctional Services that we need to urgently meet to deal with the issues that relates to the AVR system. And of course, we're then expected to provide quarterly feedback to the portfolio committee of correctional services in this regard. In the next slide, as part and parcel of the support to the magistrates, we wish to also indicate that so far we have procured about 2,479 laptops. This is both for the staff members of the department, which also covered the judicial officers in this regard. And this was done in 2023-2024. In 2024-2025, the department has also procured about 2,014 laptops, including the desktops, and those have been allocated. We are, Chair, looking at finalizing now the procurement process. In fact, that process has been finalized. It has been awarded. We are looking at the provision of about 1,000 desktops to the officials of the department, which are officials who are the core face of service delivery in the department in the various provinces, which will then, in the main, those officials will then be in a position to then directly support the judiciary, being the magistrates, in this regard, to perform their responsibilities. In the next slide, we reflect that the department has agreed with the chief magistrates, and in a meeting that was convened last week, the discussions had been ongoing. We have agreed now that we are going to be procuring for the chief magistrates across the country about 50 2-in-1 tablets. What are waiting for the audit, and we're expecting that no later than close of business day on Friday this week, we should know the actual number of the magistrates. This is Also in the main, to ensure that the work of the judiciary is unhindered, particularly the senior and chief magistrates who are expected then to receive the necessary support in terms of the tools of trade. In the next slide, we're also reflecting, Chair, that as part and parcel of our endeavors as a department to ensure that the court proceedings proceed unhindered, we are in a process now of ensuring that about 45 courtrooms are provided with the necessary capacity between from now until the end of March next year, the current financial year, or with the virtual court rooms and functionality. There is an amount of about 35 million, which has been allocated from our IJS to make this a possibility. Again, this will enhance the work of the judiciary to be more effective, and in particular the courts. And we are anticipating that by the end of March, this will have been finalized as soon as possible. In the next slide, I'll be guided, DM, if we need to proceed from this slide, or the DM will deal with it around this.
No, Chairperson, I will take over from here again and to conclusion.
Thank you, DM.
Yeah. Thanks. Okay, no, Chairperson, and thank you very much to the acting, let me just also, thank you very much to the acting DG and DDGs Mohalaba and Titi for dealing with that part of the presentation. I think in terms of the way forward at a policy level, we have committed ourselves as the executive, led by the President, to a single judiciary and a judiciary-led court administration. So we are at the moment, as members, as honourable members would have seen, there are a number of areas, be it in terms of infrastructure, in terms of ICT, security, water, electricity, those things that are the responsibility of the department in respect of the courts, and in particular the district and the regional courts. However, we're moving towards a situation where in future the judiciary, just like Parliament, would be regarded as an entirely separate, independent arm of the state in respect of financial and administrative matters. Can we move to the next slide, 27? So on the 5th of June of this year, the President announced that the Minister of Justice and Constitutional Development, or following the President's announcement that the Executive is committed to moving towards a judiciary-led court administration model, the Minister established a joint task team with the judiciary, led by the Chief Justice. That task team was given a deadline by the President of 6 weeks to have its first meeting and to come with a report. That deadline was substantially adhered to. And that meeting resolved that the transfer of court administration and operational court services from the Department of Justice to the Office of the Chief Justice should be done in phases. Phase 1 would involve the immediate transfer of shared services such as facility management, security services, court recording, transcription, library, ICT services that relate to the so-called superior courts from the department to the OCJ. Now, these shared services are not provided for in any legislative instrument, and the transfer could be effected through a directive from the Minister to the accounting officers of the Department of Justice and the OCJ. With the magistrates' courts, it's a little bit more complicated, and we'll come back to that. But it was resolved that phase 1 should be transferred with effect from 1 April 2026. So the start of the next financial year. Slide 28. Now, phase 2 is a bit more of a challenging phase, because there's a lot of policy issues involved there, and I think it's maybe an appeal, Chairperson, to the Select Committee and your counterparts in the NA and the Portfolio Committee, I think, to start putting on your thinking caps, because there's going to be some quite exciting but also challenging and complex legislation on its way to you. Now, in terms of phase 2, it would relate to the development and the promotion of legislation. The legislation will be anchored on the following principles. Firstly, that the judiciary must be able to determine and control its own budget, just like Parliament. Secondly, it must be able to employ its own staff and determine their conditions of service, just like Parliament. Thirdly, it must be able to fulfill its administrative and operational requirements, just like Parliament. Fourthly, that the Office of the Chief Justice be reconfigured as a judiciary administrative entity. Now, I mean, that may be a little bit unique. I don't think there's an immediate parallel with Parliament. I'm going to come back to that a bit. The fifth is to make provisions for the judiciary's governance structures, such as a judicial council and a courts advisory body. Now, that is where things become a bit complex and challenging, because there are two broad principles that we need to reconcile here. The one is the fundamental principle in the Constitution of openness, transparency, and accountability. We can't have any arm of the state utilizing public money, public resources, and not accounting for how those resources are used. The other principle is the independence and the dignity of the judiciary and the role that it occupies within a constitutional democracy. So the challenge is, how do we structure a governance and an accountability model that provides for adequate accountability towards Parliament as the elected representatives of the people who exercise oversight, who is the body that approves the budget, and at the same time not subject the judiciary to positions and processes that might compromise its integrity and lead to a blurring of the division of powers between the different arms of the state. And that's really where a lot of the debate and the discussion and the research is centered around, is trying to come up with that appropriate and adequate model. The sixth would be to create a platform for the judiciary and the executive to interface with departments such as Public Works, the Police, Justice and Constitutional Development, National Treasury, and others, that we, as the executive, can fulfill that constitutional obligation that we have to support the judiciary. Slide 29. Now, it becomes a little bit more complex when it comes to what are currently still referred to as the lower courts. And I think that's really a terminology that we want to try and get away from as soon as possible. But the institutional models report that was submitted to the executive in January 2024, that's now institutional models in respect of governance and accountability of the judiciary, stated that the judiciary's view on the transfer of district and regional courts may be a complex matter that will require further consultation with the executive. However, the vision to create a single judiciary the department is the view that the transfer of the lower courts to the OCJ must be factored into the final model agreed to by the executive and the judiciary. Put in more direct and plain language, the minister has made it very, very clear that the issues of a single judiciary and a judiciary-led court administration model must go hand in hand. We can't move towards judiciary-led court administration and leave a significant part of the judiciary behind. So to that end, the department has conducted an audit of court-related functions that need to be transferred to the OCJ. There are some areas such as the magistrates, the administration of the Magistrates Commission and the Rules Board for Courts of Law that can also be transferred quite quickly as a first stepping stone to achieving that full independence. Slide 30. And I can just assure the chairperson that I am two slides from completing. Now, given the minister's various statutory responsibilities in terms of the magistrates' courts and the Magistrates Commission, Minister and Deputy Minister convened a meeting on the 7th of November with the regional court presidents, the Chief Magistrates Forum, and the chair and the deputy chair of the Magistrates Commission. And the purpose of that meeting was really just to ensure that the leadership of the regional and the district courts are kept fully abreast of these developments that are taking place. We made a presentation on the key proposals on these different institutional models. They said that regrettably they had not been furnished with that in the past, and they thanked us for bringing them into the picture. The key policy issues that they will have to grapple with would be the proposals made in the institutional models report that the move of the lower court judiciary be moved at a later stage following engagement with the judiciary and the executive. Secondly, the participation, next slide please, of the so-called lower court judiciary in the governance structures. Thirdly, the integration of the lower courts bill and the magistrates bill in phase 2. Just to say there is that for quite some time, there has been legislation being developed by the department making certain changes to the structure of the district and the regional courts. And I think in consultation with those two bodies, we've agreed that it doesn't make sense to proceed with that legislation separate from this overall process. Then also the audit and the review of all legislation that would impact on the second phase. That we've got to get inputs from the regional court presidents and chief magistrates. As I said, the so-called Ngwepe report was shared with them. And the conclusion was that the regional court presidents and the chief magistrates fora have established a 5-a-side task team that will serve as a body to be consulted on this process. And we've agreed that we will meet with them again sometime in January once that task team has been able to process these matters. Chair, I just conclude on the basis to say that I think it's a very, very exciting process that we've embarked upon. For me personally, I think it's very meaningful because my first term as Deputy Minister of Justice was from 2009 to 2013, before I was redeployed to COGTA, to local government for the next 7 years. It was during that time when Minister Jeff Radebe was the Minister of Justice that the first steps were taken in the direction of full institutional independence for the judiciary through the creation of the Office of the Chief Justice. And this in many ways is a continuation of that process that's mandated by our constitution, and it's one that I think will also address many of the other issues raised by organizations such as JOASA and ARAMSA about whether magistrates should have the title of judges and so on. I think those are all issues that are busy being addressed in this process. Chairperson, I conclude just by making the remarks that correctly the Select Committee has responded with urgency and alacrity to the sight of magistrates standing and protesting and to the correspondence that it has received. And it's correct that the committee is seized with these matters, is giving attention to it. Our plea would just be that we all collectively go about dealing with these very, very important and urgent matters in a way that's consistent with the Constitution and the law, and that in a well-intentioned attempt to address these matters, we don't inadvertently cause other challenges. There are existing structures. There is the overall leadership of the judiciary led by the Chief Justice. There is a Magistrates Commission. There is a Regional Court Presidents Forum and a Chief Magistrates Forum. There's an independent commission on the remuneration of public office bearers. I think whatever we do, I think we should be done within that constitutional and statutory framework. But Chairperson, that is our presentation. We hope that in our modest way we've been able to meet the expectations of the committee, and we look forward to any questions and engagements. Thank you very much.
Thank you, DM and your collective. Just to caution in future, you would know we have a time period that we are supposed to be finishing the meeting. And we always employ to departments that are coming before us that please, it is important when they present, they confine themselves within the time slotted for them so that members of the Select Committee are able to engage more, because of, you would know, Select Committees are for members to conduct their oversight and accountability. So I'm just saying, in future, let's consider that. And we note the depth of presentation being given by yourself and the department with regards to issues that we have written to yourselves about, issues of state of security, issues of ICT that is deployed in our courts, and as well the issue of remuneration, of which it's one of the issues that we felt that we need to find ways and come to an end with it. But as well, we note in your counsel in terms of clarity on commissions that are there that we've been engaging with regards to this issue, on what is the process thereof to dealing with this matter, so that it gets to an end of not being a concern but an issue that can be addressed according to structures as well and system in place. So we want to appreciate your presentation without wasting time, because I would want members to participate and make their inputs with regards to what has been presented. I will now note the hands of members on issues that are before us. And I must say and confirm that Honorable Gotzel, who has been consistently raising the issue of security with regards to the magistrates, has indicated in one of the cases that he has forwarded before my office that at least the issue of protection was responded within 24 hours. And I can attest to the presentation that we got that now on issues of high risk and threats based on the profiling and assessment, the department is able to respond on within 24 hours. It's one thing that I want the department to note, that on our side we had a case in point of the incident that happened here in Cape Town, and the matter got an urgent attention within 24 hours. With that being said, members, I now note your hands, and thank you as well DM, for clarifying and indicating to us that you are the person delegated by the minister to deal with these issues that are before us. So you are actually relevant for this particular meeting, as I'm noting hands from members with clarity-seeking questions and comments and input, because as the Select Committee, we believe in corrective oversight rather than a judgmental oversight. We will advise as this team on what we think it's best that can be done based on our oversight that we have been undertaking as members, individually and as collective. I'm noting hands now. I see Honorable Gotzel. It will be Honorable Gotzel and Honorable Billy. For now, it's only to Honorable Pala. I've noted your hand as well. These are 3 members that one is noting hand. Let me just check because I can see there are some hands that are popping up. All right. Then it will be Honorable Nowe, Honorable Mampuru, Honorable Kherik, and Honorable Nonkonyan. Over to you, Honorable Gotza.
Thank you, Chairperson, and thank you to the Deputy Minister and the officials. Chairperson, yes, I think the representation is very welcomed. I am mindful, of course, of time, seeing that there are several hands. And I just wanted to say that the last part of the presentation about the single judiciary, in fact, it does raise a lot of questions. And I can understand also that there is still a lot to be done. And I would like to propose that at some stage, perhaps we have an agenda item which focuses only on that. I myself personally have a lot of questions. For example, if, whether we would have a more open and transparent process for the appointment of magistrates as we do for judges, if we are going to have a single judiciary, but that's just one of several questions. So, I also thought that I would only focus on 1 or 2 aspects then of the presentation. And I think that, the Deputy President's, Deputy Minister said rightly that magistrates are not employed by the Department of Justice and therefore that they are not in control of their remuneration. But they are responsible at the moment for their working conditions and their safety, and these are the issues that really have come up recently as very important. And so I'd like to ask firstly to the Ministry, in light of the horrific incident in Mitchell's Plain, where a magistrate was followed home and threatened, and where 2 women who cared for the children who was the subject of that court case was subsequently murdered. How does the department reconcile this with its claim that specialized protection services for magistrates are in place and effective? And why I ask that is that the department itself admits that 39 magistrates have reported threats, but that only 12 currently receive protection and that 4 were denied protection because no direct link was found. So I'd like to know how this threshold is determined. The matter, of course, that I'm referring to is the one that you also alluded to earlier, Chairperson, of the magistrate in Mitchell's Plain. Then beyond immediate protective measures, what long-term strategies is the department implementing to ensure judicial officers can perform their duties without fear? Further on the security issue, the presentation concedes that there is a financial deficit in providing judicial security and that threat levels are increasing. Now, what urgent steps has the department taken to secure additional funding, and what is the timeline for the closing of this deficit so that no magistrate's safety depends on available budget rather than risk? Chairperson, moving on to the other issue about the link between SAPS and magistrates' courts, as well as the Department of Correctional Services. We have seen recently that there were 10 escapes from police cells in the Western Cape, actually in the Cape Metro area, just in the past month. I'd like to know what mechanisms there are or which exist between the Ministry, SAPS, and the Correctional Services, as well as maybe the Magistrates Commission, to assess how these repeated security failures increase the risk to magistrates, especially those who preside over gang-related matters, child removal, or domestic violence matters. I see that the Provincial Police Commissioner has now said that these were administrative or erroneous releases, administrative bungles, but I don't think that addresses the safety concerns that magistrates have, and also obviously members of the community. I would like to ask the Minister, I'm very grateful to hear of the other measures that's being put in place, and of course I believe that AVR courts are very important and we should be using them as soon as possible. I see money would be made available for procurement, and I think that it was for the AVR courts, but I'd like to know where these will be spent. If we look at the amount of remand detainees who are currently being transported between Goodwood and from Goodwood and courts and Pollsmoor prison and courts, we can really cut out a lot of risk and a lot of cost if we take special instances where these courts can be used, so simple postponements, bail, etc. And then I would like to ask the Deputy Minister, is there any conversation about having dedicated gang courts? You yourself have now noted that a lot of the gang and drug issues emanate from between the community, but actually they are fueled within our correctional services facilities. I myself have been to the Goodwood facility to see how remand detainees are processed when they come back from courts. And I can tell you, Deputy Minister, there's a massive gap, and we urgently need to start looking at biometrics and other measures. But for now, I think if we could perhaps start a conversation about dedicated gang courts and dedicated AVR courts to make sure that we do not put communities, police officers, and our magistrates at risk when these matters are heard. Then lastly,
thank you. As you conclude.
Yes, so the last thing I just wanted to raise was about working conditions. I have spoken to a member, Department of Justice officials who work in the Bellville Magistrates Court. They have not had air conditioning this entire year, and for example, yesterday in Cape Town it was 37 degrees, and my concern is that this type of lack of maintenance severely affects service delivery. I myself was a clerk of the court many years ago. I know how badly one can be affected when you have to do filing in 37 degrees, and I'd like to ask whether there's any plan to perhaps see these types of neglect as quick fixes. For example, the fixing of air conditioning. If we could maybe look at that to improve service delivery, I would be very grateful. I have written to the Department of Public Works, of course. I understand that they're also involved. But I think a coordinated project between the two departments would be very welcomed. Thank you, Chairperson.
Thank you, Honorable Gotzel, and thank you as well for giving in suggestions and solutions in terms of what can be done to ensure that we deal with these issues that seeks to impede the work that needs to be done by the courts. Honorable Billy?
Thank you, Chairperson, and thanks to the DM for that presentation. I think, Chair, I want to agree with you firstly on the time that has been given to the department. I think it was way too lenient. I think the Deputy Minister could have gotten straight to the issue that we were supposed to deal with. I think the Deputy Minister spent a lot of time on the history lessons about the magistrate in the apartheid days. At some point, I thought he was going to say the collapsing state of our courts is as a result of apartheid.
Honorable Billy, can you get to the point as well, because you have noted that you are time constrained. There are times constraints.
But can I also be allowed to comment on the presentation?
Yes, I'm allowing you. Thank you. Over to you, Billy.
Now, also the issue of the singular judiciary, I think that requires a meeting of its own. And I think a lot of time was spent on that. And Chair, again, I want to emphasize that it is rather unfortunate that the minister is not here as the political head. But nonetheless, dealing straight with what I had requested that this committee do, and to commend you, Chairperson, also for allowing this process to take place after I wrote to you. I think you deserve some appreciation for that. But for me, Chair, the presentation that was provided, it really fails to address the real issues that we were supposed to deal with. Instead of hearing like concrete solutions, we heard legal summaries, long histories, and the bureaucratic process that the DM spoke about. Instead of hearing timelines as to when the issues faced by the magistrates are going to be dealt with, instead of hearing the implementation plan, instead of getting commitments to resolve the urgent concerns, we had these long histories that are not helping. Now, Chair, I also want to challenge the Deputy Minister's assertion that the department does not get involved in the remuneration of salaries negotiations. Honorable Khotsal is quite correct that the magistrate condition of services cannot be reduced to a political game between the President, Parliament, and IRC. And I think listening to the DM, it would seem like he is shifting the responsibility to the President, to Parliament, to the IRC, but more disturbingly to the President, who we all know that he's sitting with the report that he's supposed to sign. It is the department that manages the working condition of magistrates. It is the department that must address the collapsing infrastructure. It is also the department that must ensure safety in courts. And lastly, it's the department that must consult the IRC and the Minister of Finance. Now, the DM mentions the involvement of the Magistrate Commission, but we all know that since this incident happened, since all of these challenges have come out, the Magistrate Commission has said nothing at all, disturbingly so. The department has said nothing at all. The political head of the department, the DM himself, who is delegated to oversee the Magistrate Commission, has not had any engagement with regards to this issue with the Commission in its entirety, because I also sit in the Commission, and we did get to discuss some of these issues, even though I'm not going to divulge some of that. Now, to say that we are not involved, it's a pure attempt to distance the department from a crisis it has allowed to deepen over the many past years. What is even more troubling is that the very issues being presented today, delays from the President, shortages at the Commission, procurement failures at DPWI, these things were never brought up until the picket. Now, these consultations are only happening now. And Chairperson, we always get department coming here and saying that they are now suddenly having consultations. They are now suddenly discussing this and that, only when things have reached this stage. Now, Chair, my question or my suggestion, I would say that, Chair, we need to have a detailed time-bound action plan from the Minister on when the remuneration review will be implemented, how infrastructure failures will be prioritized and fixed, how magistrate safety will be guaranteed, and how this department will restore its confidence among judicial officers. To simply just say that we don't have anything to do with this is completely misplaced by the DM. And I understand the limitations and the constitutional processes that are involved, and I don't think the DM has got a responsibility to school us about those processes. They are there for a reason, to lead the department and to provide guidance and leadership in times of crisis. Now, Chairperson, I've just got one question that I want to end with. Especially with regards to, Honorable Khotsal mentioned that out of 39 magistrates who reported threats, only 12 currently receive protection. Now, the question is, what measures will be put in place to ensure a fair, timely, and consistent threat assessments and the expansion of security resources at magistrate courts? But beyond that, Chairperson, on ICT and court operations, we've got courts which don't even have scanners. Pinetown Court in Durban, court that you and I saw in Free State just recently, there's no scanners. There's lack of security. The department is unable to fix little things such as scanners to ensure they detect contrabands, firearms. There's nothing. The department is failing to do that. The department is failing to fix air conditioners. People are working in dire situation, in Hanking Court in the Eastern Cape, which I'm sure my honorable colleague, Honorable Nongonyana, will have to touch on. Because, again, if we defend this kind of things, you are going to be on TikTok defending things that we should not be defending and then complain about being on TikTok. We have to be brutally honest about the situation and the conditions that magistrates work under. And if this committee is unable to do that, if this committee is unable to call what it is for, then I'm afraid that we are failing to do our job, Chairperson. I will end there for now.
Thank you, Honorable Billy. Would now have Honorable Phala, and one would want to note that as the committee, I think we have never failed in executing our mandate of oversight and accountability. And you can attest, you've been part of this collective. So just on a parting shot, as I take Honorable Phala.
Thank you, Chair. And let me stand on the protocol which has been established in recognizing the minister and the officials on the platform. And let me appreciate a very long and substantive report, by the minister and the officials. And I will start by saying, Minister, with regards to the matter of national security, which you have said it here by yourself, which you say is at the heart of the defense of our constitutional democracy. You're quite right, Minister. If the integrity of judiciary is compromised due to issues of remuneration benefits and issues of security, that's a serious threat to the survival of our democratic dispensation. And I'm happy that you have mentioned it, and this is a thing which we as members of Parliament and together with the department, we must assist with. Chair, on the presentation by the DDG on the infrastructure maintenance and the information technology, I'll join my colleagues here and say I was in my constituency. I'm not speaking about the province. I'm speaking about a constituency that's a regional court where I met the officials. And Minister, the building, the infrastructure of that court, which is regional, is really shocking. Firstly, that is old. It was built in the 60s, and as a result, the infrastructure around it, the perimeters. People are just moving into that court, and you engage the leadership of the court. You could see these people who really want to do the work, who are so frustrated with the state of the building in which they are operating. And I went through the facility, and I'm telling you, Minister, it's disappointing. The last part, which I just want to speak about, is the joint task team established, to deal with issues of transformation. We appreciate the transformation, Minister. And as members of Parliament, we really appreciate when these matters are also shared with us, so that we know what is happening. I'm just concerned, Minister, that let me just say we will look into this the work of this task team and the proposal which are put on the table, and how the matter is going to be dealt with. I'm just concerned that if you are going to do that transfer into the to the Chief Justice, it's almost, if I'm not mistaken, it's almost taking all the functions of the department into the Chief Justice, meaning that the department will definitely have less to do. Possibly, if you can just clarify me that. But what I'm saying, I've not internalized this. We'll look into it and start it and understand exactly what is it which we want to do. But if you can just tell us, the minister, but the way I see, the way I had when you presented, when there was presentation here, this is almost as closing down the department of the Department of Constitution and of Justice and Constitutional Development. Thank you, Chair.
Thank you, Honorable Phala, for being precise. Honorable Noe, can Honorable Gotzel lower the hand and Honorable, okay, yeah, Honorable Gotzel, can you lower your hand? Honorable Noe?
I'm trying, Chair.
All right. Honorable Noe?
Thank you, Chair. Greetings to the DM and officials and honorable members of the committee. Chair, indeed, we appreciate the high-level report that we received, which has got different parts in it, and which gives us a little bit background of understanding what the department is intending to do on those aspects. But therefore, Chair, because of the oversight visits that we undertook in different provinces, in particular Limpopo and Free State, and observed state of some of the buildings, I'm focusing here on infrastructure program. If you look at the presentation, Chair, as I say, it's a high level. It doesn't go into detail. It doesn't make reference to any other area where the department is actually doing work, except to make reference that we're in process. Specifically, if you look at slide number 24, up to the end of that presentation, for me, it's a grave concern, whereby I want to make a request, Chair, that as we continue to engage with the department, in particular around that program, having seen the state of some of the infrastructure where we have visited, it will be very much important to receive where the department is saying there is day-to-day, there is a program, something is in the process. That is a grave concern for me, Chair, that we don't have that, so that we can be able to relate, say, for instance, as Honorable Billy said, in the Free State, in particular, if we go to Putarichava Magistrate Court, we have seen how dilapidated is that facility. And we don't know whether in this submission is that magistrate covered. So in the whole country, in terms of this presentation, we don't have an idea where this is happening. So I think we will need to have that detailed report that breaks down effectively where the department is busy. I was going to ask Honorable DM that when did he join the department, and he fortunately indicated that period. Now, I was going to ask DM, if you look the period in which you joined the department, and I know at some stage when we engaged, you did mention that you do some impromptu visits to some of the magistrates or some are official. And having looked into those facilities, you will have come across what we have also seen. But if your report in 2025, it says we are in the process, it doesn't give hope at all. It's like it's just giving us to satisfy us that we are in the process, but it doesn't say that we are actually doing the work. And what we are interested in is the work that we are doing, not being in the process. That becomes so general and that becomes so vague for us to really believe that there is any work that is going on. So I will therefore, Chair, submit that report, that as far as the infrastructure program is concerned, we need a detailed breakdown report around it. Thank you, Chair.
Thank you, Honorable Peter, and your confirmation that the history is important. At least you're noting that something that you wanted to ask has been addressed by the DM inputs. Honorable Gerik. Honorable Gerik. Honorable members, am I audible?
You are loud and clear.
You are audible.
Okay. Honorable Gerik. Okay, let me pass.
Honorable Gerik just informed me that there is a problem of network where he is. So hence he's struggling to log in. Thank you.
Okay, you can then come in, Honorable Mampuru.
Yeah, thank you, Chair, and greetings to honorable members. Chair, you know, as I was listening to honorable members here making inputs, one will then appreciate that there are three core factors which are rising above everything. You know, the issue of security of magistrate, the issue of infrastructure, and also remuneration. But I think, Chair, it will be also to save time, go to the issue of infrastructure. Chair, you know, I in the report, I had it been saying that they are now embarking on a day-to-day maintenance of some of the infrastructure in the magistrate courts. But one will wonder, Chair, how day-to-day is it day-to-day? Because in some of the magistrate courts in particular, I can give an example of Devon magistrate courts in the region of Sidibeng in Lesedi. I think it has been a fourth year now in their holding cells where the toilets are not working, the windows are broken, the blanket like that holding cells on its own is just the mess. The list said about the magistrate court on itself, Chairperson, its benches are broken, transcripts are not working. Like, you do not know what is it that is working in that magistrate court, which makes it extremely difficult for the magistrate herself, because it's the resident magistrate court. The magistrate herself, it's making it difficult for her to do her job. It's extremely difficult. And the report comes here and say, and it's not the problem, like Honorable Noah have said, the report is not explicit. It's just an overview. We do not know which magistrate courts are being attended to. Where are those magistrate courts which have been attended to? Because the ones that we have seen ourselves, this again, Chairperson, the less said about the Naval Magistrate Court, the better. Because one will say, maybe the magistrate courts which are being maintained are not of this world. Because the ones that we have seen, Chair, surely one will say, maybe that's one of the reasons we are seeing some of the magistrate courts are not doing their work, because it is not encouraging even for them to go to work at a place which is not conducive for them themselves. So it's a problem. And just to go even near, you can go to Sea Point in the holding cell, just here in Cape Town. Just go to Sea Point in the holding cell.
you then see that not much is being done to improve. Yes, I agree. Some of these buildings were an apartheid buildings, maybe because they were meant to hold people at that time. But now we are in a democratic dispensation, Chair. But just to look at them, you wonder whether the department is doing justice. And Chair, lastly, just to save time, because most of my inputs have been covered. The picket, Chair, which was done there in KwaZulu-Natal, I think I wrote a question, if I'm not mistaken, a month ago to the department to get an explicit response on how is going to cover or to address those issues of remuneration. Because we complain about judiciary being captured and magistrate being captured, but we ignore that some of the contributing factors towards that is lower remuneration and security, because they don't feel safe. And just the last one, Chair, we are told that on magistrate who have reported the issues or the cases of intimidation and threats, out of the 39, 12 of them have received assistance. One will wonder, how is this assessment made? And after they've made, how are they going to make sure that they never continue? And of all these cases which have been reported, Chair, how many of the people who participated in the intimidation of magistrate were arrested and ultimately convicted? Thank you, Chair.
Mampuru, and indeed we would need specifics on these cases. It's something that it's of important that one have noted as well, that we lack information with regards to what has been presented before us on this matter. Honorable Herrick.
Yes, Chairperson, thank you. I'm back online. Am I audible?
You are audible. You can continue.
Thank you, Chair. I'm going to touch on 2, 3, 4 issues, which I think is very important. First and foremost, the DM, thank you for your input and everybody else's input. We understand the presentation fully. We also understand, DM, just for the note, for a mental note, we do understand the separation of powers and the delegation of powers. We are not so elementary. This is why I mentioned in my initial inputs that when the delegation comes with power, and thank you that you expanded on the fact that the delegation comes with power, that you made it clear that that power is vested in you, bestowed upon you in your portfolio. The second issue, Chairperson, this conversation is such an important, critical conversation, and I don't think we must sit here and fight with one another. I think we must just flow and try to seek solutions on behalf of those that were boycotting, standing on the street, demonstrating, and on behalf of those that are despondent and looking at us for solutions. Because if we do not look after our magistrates and our judges and those that speak the law, we may easily slide into a collapse, and our role may be construed as if we are useless and mean nothing, and if we slide into that collapse, the rule of law will also collapse. This is a very critical, important point that I am making, and we must stop it. We must stop at all costs that we do not slide into that thing and that we are being perceived as useless, but that we are being perceived, should be perceived as a very effective committee that stand up and that does the oversight in a decent way for the people that look at us. I want to ask the following, and the question is based on what the minister has said. I do understand that the remuneration and all those other things are not on the Department of Justice, but there's the Magistrates Commission and all those other bodies connected. But we are aware that the budget is seated within the Department of Justice. In other words, when there's budgeting in a process in the year, the annual budget, the magistrates' budget, the judges' budget, and all those budgets are included into the Department of Justice. Now, although the budget is included there, there's another body that's responsible for the other benefits and the rules and regulations and so on of the Magistrates Commission. But we must separate here, Chairperson, and this is where we need to have some kind of clarity from the Deputy Minister. If you pay the remuneration of the magistrates, and although the authority to rule and govern their business is based on some other body, how do we bring the legitimacy, or shall I say, what locus standi does the department have towards the magistrates? What responsibility do they have to look after the magistrates over and above funneling or channeling their salaries and so on? Because effectively, when the Department of Justice pays them, they deduct their pension, they deduct their medical aid, they deduct everything. So what responsibility does the department have towards the magistrates? I shall think, I have not studied this, but I shall think that the Magistrates Commission, for instance, is there for the administrative implementation of some of the issues or some of the benefits or rights or regulations in terms of what the magistrates want. But I should also think that the Department of Justice is primarily responsible for the execution as the custodian of the magistrates' salaries, remuneration, and how do you bring that separation there? How do you say no? We are not responsible, but you governing the remuneration. I don't know if I'm clear on this, but this is what I'm trying to get at. Yes, in terms of the Constitution, in terms of other laws, the Magistrates Commission, their mandate is stipulated in some other documents and some other legislation, but the situation is the same, Chairperson, as with the police, as with IPIT. The situation is the same as with the correctional services, as with JICS. And we need a clear body, a primary body that must take responsibility for the remuneration, for the rights, and for all those other things of the magistrates and for anybody else. And therefore, there needs to be a separation of those powers and clear-cut separation. The other issue is, if the Magistrate Commission was aware that the magistrates received an increase so many years ago, backwards, I mean, why is it that the Magistrates Commission is not advocating on behalf of the magistrates? I'm sure they had requests to speak on behalf of the magistrates. And if they have submitted some concerns from the side of the magistrates, where did they submit the concerns? Does the department know about it? Has it been discussed? Has it been brought together? Was there a meeting of the minds that say, we are here in a problem because these people 10 years back, 8 years ago, they have not received the increases. What are we going to do about it? Has it been discussed on the public service platform? And what has been done about it? Lastly, what would the Department of Justice say when it comes, and I know that you're going to tell me most probably that we won't have an input, but I mean, these people are standing in your service as a department because you are primarily responsible for paying them their salaries. What would the department say if there's a meeting tomorrow between the Public Service Commission, the Magistrates Commission, and all other interested bodies, affected bodies? What would the contribution of the Department of Justice and Constitutional Development be towards saying we are in favor of an increase or we are not in favor? What would your position be at that stage where all the parties are coming together? Thank you, Chairperson.
Thank you, Honorable Gerik. Honorable Nonkonyane, Honorable Gerik, can you lower your hand?
Chairperson and honorable members and our guests led by DM, good afternoon. Colleagues, and first of all, we need to understand, and I want to thank and join you also to thank the department for a very comprehensive report, which is based on our invitation. I think the very first slide clearly states that the department is here on our invitation after we did receive, of course, the concern from the magistrates as well as from the Magistrates Commission. And we felt quite correctly, Chair and honorable members, that we need to invite the ministry. And the ministry just did that and says the purpose of the presentation is to address the concern raised in relation to, one, the remuneration benefits of magistrates, two, the working conditions at courts, and three, safety of magistrates. And the report that I've read and the submission that I've heard clearly addresses those issues, Chair and honorable members. And for us or any one of us suggest that it does not address the issues, it is, with respect, unfair. For instance, Honorable Bailey is actually very critical and against the report, and particularly against the absence of the minister, which has been explained. And I'm not going to go there in the interest of time again, Chair. But it's quite clear from the report that there is an issue, which we all know, about the infrastructure, a Department of Public Works and Infrastructure. We don't issue any missiles against that. Why? Is it because the minister there belonged to another party? I don't think that is so. But we, as this committee, has been going around in Limpopo and in Portsmouth Prison, and this issue has been cropping up of the issue of the infrastructure. And we did actually engage the relevant minister on that. I don't think that we must forget about that. And again, on the issue of correctional services that are under the other minister, we are not saying anything against that minister now. And we don't want to think that it is politically driven to really, for Honorable Billy to really point out and criticize the minister whose absence has been condoned by ourselves. I think it's grossly unfair. And then we must put it clear. And I'm not so sure, because I think Honorable Gottsel has been very good in this, dealing with the issues and actually bringing to our attention the real issues that we as public representatives in our oversight responsibility need to follow up. Hence, I'm confused whether Honorable Billy is on a frolic of his own, because I thought that perhaps he was sent by DA. But to me, that is a concern, Chair. The other issue that I would like to remind members, you will recall, Chair, that when we were considering the issue of remuneration of members of the judiciary, and we had to delay actually endorsing the determination of the commission after the NA had considered this matter and referred to the president. And all of us must be reminded, I think it's Magistrate Saunders, if my memory serves me well, who also had submitted something here. And again, we considered that, and we were amenable to those concerns, all of us across parties. And now that the department has actually constituted task teams and the president has been involved, and the DM quite correctly pointed out that there are various parties that we need to consider. Amongst them, the issue of, the Commission on Remuneration of Public Office Bearers, that we are all aware. And we were briefed by the Magistrate Commission about that process. And I am therefore, Chair, of the view then that really let us thank the department for what they have done. I think they have empowered us in our oversight role to really address. It was not only the magistrate in KZN, I also were told, in fact, I'm aware that even the Eastern Cape, they were all concerned. In fact, not only those two provinces, all over South Africa, they were having similar concerns, which have been addressed. And the issue of the CJ and the separation of powers has been in the public domain. Yesterday, we did receive the Judicial Day input from the Chief Justice herself, and who actually pointed out the challenges around the issues that affected the magistrates. Not only that, because there is also an issue of public prosecutors that are remunerated better than the magistrate, which has caused tensions, because from time to time, and you would graduate from being a public prosecutor and then elevated to the bench. But now it looks like there has been some tensions which has been caused by the prosecution, NPA actually remunerating the officials better. And I am therefore, Chair, of the view then that really we have been empowered by this presentation, and I hope then that all of us will be empowered to really do our responsibility to oversee the executive in executing what they need to do, and to support them when they have done correctly, as the team that is being led by the DM has done today, instead of actually vilifying them and filibustering them, and for what I think is for political consideration rather than reality. Thank you very much. I hope I've made sense in my contribution. Thank you, DM. Thank you, the team. Thank you, Chair. And thank you, honorable members. That's my contribution.
Yes, thank you, Honorable Nonkonyane. Honorable DM and the collective wants to indicate that I only have 3 questions that I would want to pose from my side as the chairperson, and some of the issues have been dealt with by other members, more especially the issue of ICT. I think we can all agree that the ICT is no longer negotiable, but it's something that we need to implement now in terms of upskilling ourselves and as well upgrading the services that we are dealing with on daily basis. So that issue, it needs not to be compromised. And members, they need details with regard to specifics based on provinces, because now at least you have given us the high level, but can we get specifics per province? Because you would know the NCOP focus is the interest of different provinces. And the other thing that one would want to check is that with all these dysfunctional systems, are these systems disposed, or they are still there in our courts just lying recklessly? It's something that one would want to get sense on, because we know if we have dysfunctional systems that are just lying, we are actually promoting criminalism, or people to just take home and then use them for something else. So I want to check if they were thoroughly disposed, and if we can get confirmation around that. The other matter is with regards to X-ray machines in courts. As they have alluded, members, they have observed the Free State issue, that it's not something that is good and appealing to them, that you would find that a court doesn't have an X-ray machine, of which some of us believe that is the base of dealing with risk factors in situations that we are dealing with. So we want to check, can we get as well specifics on those provinces that has X-ray, that doesn't have X-rays, up until to their regional levels. The other matter that one would want to emphasize, as alluded by Honorable Peter Noe, is the issue of, let's get as well the breakdown in terms of infrastructure maintenance program. Because Honorable Mampuru asked a question, what is that day-to-day maintenance? Let's get specifics per province, per regions, and as well localities on what is it that you are talking about, based on what has been explained by Honorable Mampuru, that the situation that we find ourselves in our regional courts is not exactly what we must say we appreciate from the report itself that we got today. The issue of procurement of laptops and tools of trade, one would want to check if you do have a procurement policy with regards to that, and is this procurement of these tools of trade issued fairly, or it depends on the level of one's task and work that one is doing in the institution? Can we just get some sense on how do you actually deal with this particular process? We are appreciating the details that have been given in terms of the phased approach of shared services. It's something that we think that, as honorable members could have said, that there's a need of us convening a meeting with regards to all this that has to do with these shared services, and as well the matter of single judiciary as part and parcel of perhaps we can have a colloquium with regards to those issues, because if we can get sense of what is it that would want to achieve in dealing with current challenges that we are facing in our department, we would be able to, appreciate and work together with the department in ensuring that we better the services. But if we still have a misunderstanding of what is it that we would want to address by bringing these services to our people, and as well like products that we would want to sell to our people in terms of the services that we do. If we still have misunderstanding on how the operations are, we will never find the solution. And I appreciate members who have spoken before, like Honorable Gerik, in terms of reprimanding and reminding ourselves that, this space is one of the space that we need to use wisely to ensure that we address issues that are impeding to services of our people. Like, for instance, we know we have high cases of sexual offenses, and just dealing with something else that might not bring that solution to our people, I think we might be failing them. So we take the counsel, Honorable Gerik and Honorable Nonkonyane, that we can do better as we've been doing as this committee. I want to now hand over to the DM and the collective to respond to issues that have been raised, but as well noting that members were not just raising issues, but they've even given yourselves solutions on how to deal with other matters. And mostly, I've noted from Honorable Kotel that he had questions and as well comments and suggestions to say, this is what I think that can be done to improve the services in our spaces. Over to you, members. Colleagues from the department.
Chairperson, thank you very, 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 very much. I think just at the outset to say that as a department, we always value these engagements, because when it comes to the pursuit of justice for all in our country, when it comes to striving to realize the values and the provisions and the promise of our Constitution, I think all of us, no matter what party we might belong to, we are on the same side. And these engagements with the Select and the Portfolio Committee exercising vigorous oversight really enhance our work in the executive, because it enables us to see things that, as much as we try, very often your eyes and ears can't be everywhere at the same time. So that information for us is really vital. It's taken very, very, very seriously, and we use it also in our engagement with the department. And I think especially, and I've made this point a number of times, is that the NCOP really does constitutionally have that special mandate of bringing the interests of provinces into the national legislative sphere. And justice as classified as a national competency can benefit tremendously from those perspectives and insights. Chairperson, I think just maybe to apologize at the outset for the comprehensive and detailed nature of our report and the length that took. I did actually ask my office to inquire from the committee as to whether there was any prescribed length, but we didn't get such an indication, and maybe going forward it would be helpful to have broad parameters within which to work. But having said that, I think obviously we were trying to address quite specifically what the invitation was asking us to do. And that was to speak about those issues of remuneration, conditions of employment, the conditions of the courts in relation to the issues raised by the magistrate. So we were of necessity trying to give a broader, more comprehensive picture. But we would very, very happily take up the request and invitation from the committee to come back with a presentation that goes into detail much, on a province by province basis. But if we had done that, as members are now suggesting, I think our presentation would probably be 2 or 3 times as long as it was. But I would also ask that when we do have that follow-up engagement, it would be helpful if we did it not just as the Department of Justice alone, because the reality is that for our justice system to function properly, it requires a collective input by the executive. It requires the financial resources that are under the control of National Treasury, much, if not all, of the infrastructure which our courts function in, falls within, is owned by or leased by and controlled by the Department of Public Works and Infrastructure. A lot of the information communication technology that is used by in our courts, yes, it is procured by the Office of the Chief Justice or the Department of Justice, but we do so through the State Information Technology Agency, SITA, which falls under the Department of Communications and Digital Technologies. Then, of course, issues of court security are intimately intertwined with the work of the South African Police Service. Within that, of course, the courts exist within the ecosystem of the broader justice, crime prevention and security cluster. I think we've long passed the point where we engage in finger pointing and saying, well, the courts are not working because of SITA, because of public works or whatever. I think Minister Kubai has been very, very proactive in bringing all of those departments together. And I must commend all of them for responding without hesitation. But I do think when we come back for that more detailed province by province presentation, ideally, it should be the Department of Justice, together with Public Works, together with SITA and communication, and the South African Police Service, so that the committee can also benefit from an all-round view of which department is responsible for what areas. I think I don't want to precede because I'm going to ask the acting DG and DDGs to respond to matters of detail, but just to say up front that I think we need to distinguish, and this thing always causes confusion. It even confused the Auditor General. This thing of the small capital works budget. The issue that we're confronted with as justice is that all of these court buildings are either owned or leased by Public Works. We can't, as Justice, go in and change and repair things that are not ours. It's we're going to be intruding into the domain and the mandate of another department. Two, it's going to give rise to audit queries, because how do we spend money fixing buildings that don't belong to us? So we have to work through Public Works, but we've made provision for an amount of up to R1 million to be able to be utilized to attend to the most pressing immediate things that require intervention in our courts. But always when we report on that and we don't explain thoroughly enough, people then misinterpret it as being the budget for the maintenance of our courts, and it's not. And I think the officials can explain that a bit better as they respond. So, Chair, with you, can I ask the acting DG and DDGs Titi and Mohalaba, in whichever order they think is best, to respond to the matters of detail? I'll then conclude just by addressing some of the policy issues, in particular around remuneration and the issues around the single judiciary and the judiciary-led court administration model. Through you, over to the acting DG.
Thank you, DM. They can continue.
Thank you very much, Chair. Chair, I would just like to direct the questions on ICT to DDG Mohalaba. In terms of the ICT slide, where one of the honourable members mentioned that we talk about matters being in process, I think we ought to have given some kind of time frame in terms of when our process would be finished. And because we do talk about in process, but I want to also remind that that slide is about a refresh process that we are undergoing, meaning that we are replacing what was already provided to update what the gadgets that the magistrates currently possess. And then on the facilities, as the Deputy Minister indicated, we did not prepare for a full briefing on the state of the infrastructure in the courts. We have done some presentations to our portfolio committee, and we are regularly monitored on that aspect, so we can also in future ask to bring those presentations to this committee once we prepare them, because they are quite lengthy and detailed and talks to numerous challenges, but also talks to a number of matters and steps we have taken to attend to day-to-day repair, for instance, having gotten a permission from DPWI to procure up to R1 million in the relevant provinces to attend to repairs in a faster way. But I will leave the ICT issues to DDG Mohalaba and the matters of infrastructure to DDG TT. Thank you, Chair.
Thank you. You can continue, DG.
Thank you very much, Chairperson, and to the members for the questions. I will deal with the ICT matters and a few other matters within the court administration environment. Chair, I think it's quite correct that we do have some challenges within the ICT space. And the department has noted that, firstly, the ICT infrastructure is outdated. We're dealing with infrastructure that must be replaced, which includes servers. And as much as the department has made significant progress regarding the replacement of the tools of trade in the main desktops and the laptops, I think there has been good progress in that regard. But the other hard infrastructure, we really need to deal with it going forward. So 2 months ago, we have reviewed our ICT strategy, which really has a number of pillars. And amongst those pillars really have to do with the network upgrade, which is, we consider that to be fundamental. Number 2, ensuring that we replace the outdated infrastructure. And one other important element within the pillars, Chair, really deals with the issues around our cybersecurity protection, which we consider as due to the size of the department having about 20,000 users. Those being the staff members of the department, including the judiciary. So cybersecurity is an important element that we have to deal with. And of course, the issues around to what extent then are we looking at financial efficiencies, and that involves the review of our contracts as well as the licenses that we have that we're utilizing. So there has been savings share that has been identified with the process that has now been finalized within the ICT space around the contract and licenses that we have reviewed. So we have noted that progress. So there has been a review of the strategy, and of course, there should be a greater level of funding for us to actually achieve. As we speak today, there are items that are funded in the strategy, but of course, there are those big other ticket items which are not funded. And of course, we were hoping that in the not so distant future, National Treasury can fund the revised ICT strategy in this regard. There were questions around the AVR, Chair, and I think to be more specific, we have noted that in Toyando, we have one that is non-functional, we have one that is non-functional in Kronstadt, Putadechaba, in KZN, in Ladysmith, in Mpangeni, Campandown, and Watuguza. And those that have been identified to be not functional, we have set ourselves that we need to work very closely with DCS to ensure that the risk that is associated with the transportation of remand detainees to the various courts should be limited, both in terms of costs as well as the security measures that would necessarily compromise the transportation of remand detainees. So as we would return back to the committee, we shall be providing the committee chair with feedback in terms of where are we around the fixing of those that have not been found to be functional. And I think Chair, the DM would probably speak to this point in terms of his engagement with the Minister of Police as was leading the discussions with the Department of the SAPS around the issues that relates to the gangs in the Western Cape. We have noted, Chair, that the gang-related incidences, which includes the escapes that we've seen recently in the various court cells, particularly in the Western Cape, and those that have been referred to in the Free State Province, are indeed worrying us a great deal. So the SAPS is literally responsible for the transportation, for the remand detainees, as well as the ensuring that those detainees are safely kept in the court cells. And whenever there's such incidences of escapes that would arise, certainly the SAPS and in some other instances, DCS would then be responsible for those. But of course, the court officials who are in the administration are responsible for the administration of the court. So in most instances, we really rely on SAPS and DCS to ensure that those that are within the court buildings and the cells are safely secured. And given the incidences that have taken place up to so far, we have been advised by the SAPS that they are investigating these specific incidences. I think my colleague DTGT will deal with the issues around the facilities as well as the security measures. I think those are the responses, Chair, that we can provide in as far as FCT and court administration is concerned. Thank you very much.
Thank you. Your colleague can continue.
Thanks, Honorable Chair and the members of the committee. I think let me take cue from the comments that are raised by the members of the committee around inadequate details that should give comfort that as a department we are really putting some interventions to address the issues of security and the issues of facility. Chair, and I just need to start by saying we will be coming back when we are called to come and respond to this, but I need to make the following points. We have done at a high level, but also breaking it down to provinces, what we call a court security profiling, where we have gone into various provinces and identify the high risk, medium risk, and the low risk courts, so that you can be able to identify what interventions we are going to put in place. And I think our response in our next engagement will then detail that breakdown and what interventions are we doing at various areas. For an example, we have done an analysis as well of the access control movement, where we have detailed the number of areas where we have the not functioning access control measures in place. For an example, the metal detectors and the walk-through machines. We have done that profiling and we have done that breakdown so that it informs our interventions. But what I need to put to this committee today is that we are in a process of finalizing a procurement to deal with two provinces, Western Cape and KZN, as part of phase 1. And when we go to phase 2, we'll be dealing with Eastern Cape and Western Cape as well, so that we can be able to close the gaps in some of the security-related aspects that we have done in terms of accessibility of our courts. We are also going to look in terms of the assessment of the parameter fences in some of the courts where there is insufficient parameter fencing to be able to protect the access of our courts. I think that report will detail the plan. In terms of the risk of the judiciary and the interventions that we are putting in place, we do collaborate with SAPS in terms of making a determination of the level of the risk before we can make the determination of whether there's a need to continue with the deployment, or whether there's a need to assess, or whether there's a need to revoke the protection that is provided to the members of the judiciary. We do sit and have this discussion with a clear methodology that identify a number of things that will give us that indication of what intervention we should put in place. But we have put, Chair, as I've said, immediately when we receive a threat, we do a 24-hour deployment until we finalize this. Yes, in some instances, once we have made an assessment that the risk is lower, we then have a discussion on how to scale down or withdraw the deployment. Yes, the figures that we gave are only from the past financial year, and perhaps even when we come to the next committee, even if we can give what we have done for both what DM want us to avoid talking about the superior and lower courts, what we have done as the security interventions over a period of 3 years to indicate that at some point there was an increase. But in this past year, it has been sporadic, but we have managed to address it through the collaboration with the SAPS. I just need to put another point that I think will elaborate further on it, and it's what the DM has spoken about, that we had started the process of integrated court security discussions with DCS, SAPS, and ourselves, and we have included some of the critical cluster department like the Home Affairs and other structures to help us look in terms of how to address some of the security gaps, because we've made the realization that there's a value chain where in each and every point there might be a security gap, like what DDG Mahalava spoke about and what DM spoke about. Their transition from remand detainees coming into court, where are the gaps, and so forth. So we're having a plan, and I think what went further is the discussion that we held with the police to go and have a specific targeted intervention to address some of these challenges. And I think we can share with the committee the work that has been done, including the consideration that has been proposed here of looking at the biometric measures as one of the interventions to assist in resolving some of the security gaps. In terms of the facility chair and the members of the committee, DG indicated that we did brief the portfolio committee on the state of our facilities, where we did a breakdown per province of what are the challenges that we are facing of maintenance in various areas. And I think when we come back, we can just expand on that presentation to look in terms of what we have done to date since we presented to the portfolio committee, and what is it that we are going to do in the next couple of months before the end of the financial year. We will be doing that in collaboration with DPWI as we work hand in hand in addressing some of these issues. However, what I want to give is that the condition assessment that was done will also expand on provinces and also go to specific courts, so that we can give the members of the select committee an appreciation from a provincial point of view, and specifically to some of the costs that has been identified, to see what is it that we're doing to address the issues of maintenance. And that would include the issues of the refurbishments of what would be critical in ensuring that the court operate uninterrupted. Air conditions, the issues of water, the issues of the toilets, the broken windows, and all of that, so that we can give a bit of a detailed report when we come back. Chair, I think in the absence of that detailed report that we are going to give, I just want to probably apologize that maybe the lack of detail is what could have brought the members of the committee to feel a bit otherwise about our report. But when we come back with detailed presentation, there will be clarity on the work that we are doing to address some of these challenges. We do appreciate as a department that these are the issues that we need to address to ensure access to justice, and we'll ensure that our report will be as detailed as possible when we come back. Chair, thanks.
Thank you. DM, can I just have your closing remarks? And I want all of you to note, yourself and the department, there's no comeback. As the committee would want you to submit a detailed report in terms of state of our facilities, with specifics as well in terms of which building belongs to who, and the activities that are taking place, be it projects or anything that is happening. We are giving you 14 working days to give us those issues. As well on ICT, let's get a detailed written submission on the status quo of everything as questioned by members. We are not going to be calling you for another meeting with regards to issues that we can get written submissions on. When we will be calling you as a department, we'll be calling you on things that we think that they are pending. Like as I indicated, I'm taking note that members are proposing that we need to have a colloquium with regards to single judiciary, and it is important so that we get sense or what is it that we want to have as an outlook as the department with regards to that. So on matters that we think that they are there, you just need to consolidate the report to submit to us. We won't be calling you DM and your collective for a meeting. I think all of you are abreast with how Parliament works. You have 10 o'clock to 1 o'clock dealing with the issues. So I don't think, noting how this meeting has stretched, we would want to call you for things that we can get from this after this particular meeting. Hence, I'm saying that we are giving you 14 working days to go and expatiate on why, when, who, where, what, and how, in terms of the report that has been brought before us. And I think you need to note as in your collective that members are appreciating the work that has been done. However, they are raising issues in terms of the gaps that were not in detail on the presentation that has been brought before us. But they are saying as well, emphasizing that other matters that they think that there's delays in terms of dealing with them, we need to be abreast on the information. Like, for instance, the issue of this magistrate remuneration has been a long-going discussion between ourselves, between those who are asking us as the select committee on when is this matter will be dealt with. So it is important, DM, to note that Honorable Billy was requesting that Perhaps if we can get a time frame or time-bound response with regards to that issue, at least we'll be able to say as the committee, when people are asking, that matter is getting the attention it deserves. So I don't think that as one of the DDG could have alluded that members are, saying that they didn't get anything from your presentations as the department. We are appreciating, however, we say this is what we need to see happening with regards to responses that we feel that we didn't have in this particular session. Then I want to hand over to you for your closing remarks in all the discussion that have been taking place. Over to you, DM.
Okay. No, Chairperson, thank you very, very much. As I said, we really do value these interactions. And I think in particular for me, the very, very constructive and thoughtful engagements by the Honourable Godsil, Gerike and Noe and Nonkunyane and Pala. I think to maybe start off with the general point that you've just raised before going into some of the specifics raised by other members. I think first of all we will be guided by yourself and the committee as to in what form you would want the information that you would need. We can easily do that in a written report within the next fortnight. I think we have submitted similar reports in the past to the Portfolio Committee and possibly even the Select Committee. So I don't think there's any problem with us doing that. I think we were just raising the issue of saying it might, and again, we leave it to yourselves, that we engage those issues with the participation of all of the relevant departments that play a role to enable the committee also better to understand the different mandates the different departments have and how we work together as a collective. But I mean it's up to yourselves how you would want to do that. Secondly, I think we would welcome very, very much a colloquium on the issue of the single judiciary and the judiciary-led court administration model. As I've said, these things are groundbreaking terrain that we are moving into. And I think the more ideas, perspectives, and proposals that we get, the better. In terms of the Honourable Godsil, I think he has raised issues relating to the single judiciary and the judiciary-led court administration. He's posed very relevant questions like with the impact that would have on the appointment process. And I think that's exactly what we're saying, is we would need to think, are we going to have one unified judicial service commission that appoints both judges and magistrates or whatever they would be called? Or would you have separate chambers, or would the Magistrates Commission and the JSC still remain separate, etc., etc.? Those are exactly the kinds of things that we are busy grappling with. I take particular note of the matters that he's raised in relation to Mitchell's Plain, which also happens to be my constituency. So I do have a very keen interest, and I'm very active in engaging both the magistracy and the police in that area, and I would also happily have a further engagement outside the meeting with him around those matters. I think he raised a very important issue of the AVR courts and posed a question as to whether we should consider dedicated gang courts. I can just say that based on the discussion that I've had with the Judge President Western Cape, they have made a suggestion, a very constructive suggestion, that we consider proclaiming all of the correctional facilities as possible sites of the AVR courts. It's not to say that immediately then there would be AVR courts in all of the correctional facilities, but it would enable, as and when the need arises, to do that. The second issue related to that is that the Goodwood court at the moment is a extension of the High Court. The question has been posed whether we don't also want to make that facility available to the district and the regional courts, and we are busy working on that as we speak. The question of dedicated courts, I think, is always a vexed one, because yes, there's a lot to be said for dedicated courts, but I think we also need to be mindful of the views of the judiciary. We need to be mindful of issues of resources, and ultimately whether that moving in that direction will give us the effectiveness that we desire. The Honourable Pala, the issues of national security, I think we've already made it clear that our minds are in the same place, and that the issues of the transfer of functions to the OCJ, I think you raise a very, very, very valid question. Once those functions are transferred, what will be the role of the Department of Justice? It's an issue that we, the Minister and I, have raised with the senior management of the department, and we raised those issues sharply in our strategic planning workshop. There are two ways of looking at that. Some who take the view that budget and staff equate to power would see this as the department giving up power. But there's also a different, more positive way of looking at it. And that is that once those functions have been transferred to the OCJ to give effect to the constitutional injunction of a fully independent judiciary, does that not allow, I mean, it prompts the question that the department needs to reconceptualize its role. What does a Department of Justice and constitutional development do in a constitutional democracy? And I think that also opens up a lot of exciting prospects. And preliminary, we're saying, should we not be focusing on delivering better quality state litigation services? Should we not be focusing on making sure that we can give top-notch legal advice to the state at all levels? There are justice services like the Master's Office that is in dire straits. That is something we can focus on. Fourthly, there's the very important area of constitutional development and promoting constitutional literacy, knowledge, and overall respect for the Constitution. So I don't think we should see this as a department that then has nothing to do. There's also the very important role of coordination, of greater work around policy. So we could, as a department, also be entering into a very, very exciting new chapter. I think the Honourable Noe has already raised the issue of the need for a more detailed province-by-province background breakdown, and we've agreed on how to work with that. I must say I was particularly heartened by the Honourable Gericke's very thoughtful input, and the fact that he emphasized the need for us to be solution-orientated, not fighting amongst ourselves, because the issues at hand, the very fate of our constitutional democracy is just simply too important for that. Honourable Gericke, I spent quite a bit of time trying to outline the constitutional and the statutory framework within which issues of remuneration are dealt with. And I mean, I did that also for a reason, because it doesn't matter how often you deal with those things. You always need to refresh and remind yourself. And I think very often we have a duty to share whatever knowledge and information that we have. And I mean, I have the benefit of having been part of the Constitutional Assembly and having been part of drafting the Constitution. I mean, the Honourable Billy, didn't have that fortune. I think he was about 6 years old when the Constitution was adopted. But I mean, those who were part of the process, I think, do have a duty to share the knowledge that they've gotten through whatever experience that they've had. And I was trying to do that. because I think we need to be it's not the question of the department running away from any responsibility. The fact is the minister has written to the independent commission urging them to engage with these voluntary organizations of magistrates. But the reality is that it's not the Department of Justice's constitutional and legal function to determine the remuneration of magistrates. We can make inputs when the time comes for us to be consulted. And I wouldn't want to preempt the minister's views. I think it would not be correct for me to do so in this forum, other than to state that obviously the better remuneration and conditions that can be provided for district and regional court judiciary, the better. But there's also a complex series of factors that need to be taken into that. But the fact of the matter is we don't determine those things. We can't determine them. It's wrong for us to determine them. That's why at the outset of our democracy, we said those matters must be determined by an independent commission, just as we as members of parliament don't determine our own remuneration. It's determined by the commission. The president agrees to our remuneration. The commission makes recommendations regarding the president's remuneration.
We as to conclusion.
Yes. Yeah, yes. We as parliament take the final decision on that. So it's a delicate web of checks and balances. There was a lot of thought that went into developing that system. So it's not a shifting of responsibility. It's saying that we need to act in line with the Constitution and the laws of the Republic. When it comes to other areas of the working conditions of magistrates, yes, as we explained, the department has a responsibility in that, and we've reported on how we are discharging that responsibility. I think lastly, just to again re-emphasize that as the executive, justice, police, public works, DTIC, Treasury, we all have that collective responsibility, as the Constitution says, to support the judiciary in the discharge of its duties. We hope this report gives you some indication of what we're doing, and we will within the next 2 weeks provide a more detailed and provincially broken down a report to yourselves, and we look forward to any further engagement after that. Thank you very much.
Thank you, DM, for detailed remarks. I must say that in future, when you meet with us as the select committee, please, you must know that we are very time conscious, because you would know members of the NCOP, they sit in different clusters. So you have many meetings as an individual that you need to attend to. So hence I have been indicating that you must close up. But we got the sense, and we really appreciate your presence in this session. And one would want to just emphasize that in terms of what we need for submission is with regards to the protection services in detail, in which provinces has those services been provided to, and as well the issue of we note and appreciate the remarks about designated courts for the gangs issues and drugs, as alluded by Honorable Gotzel, is something that we can engage in future and look around how we can bestly do that. And we appreciate, DM, that indeed you are confirming that it's true when department says that they cannot work alone in ensuring that they bring best services and quality services to our people. We appreciate the integrated approach that you are presenting before us, that you are making strides to ensure that it works and it becomes responsive to issues that their sister department has to deal with them. So we would want as well perhaps things that have been done through the leadership of the minister in terms of integration services, if we can get something that has to do with that as well on your written responses, we would appreciate. Status quo, as I said, of ICT per province, it is important that we get that. As I asked, it should have as well the indication of disposed assets. If you have them, just give us a brief. What is the status quo with regards to that? And if those disposed assets are liabilities or we can still reuse them, can we just get the indication with regards to that? But Nje, I thought one of the things that you didn't speak on is criminal cases around these 39 high-risk people. We would want as well the report that speaks to that with specific breakdowns. If we do have arrests or not, can we just get that particular report? It will assist us as we do our oversight, even during constituency period. So that's what we need from yourselves as well. And lastly, the issue of maintenance as raised by Honorable Mamburu. Can we just get a comprehensive report, DDG, on what is it that is happening in each and every locality, noting that at DM you have said that in other spaces you are not fully liable to maintain and do repairs, but it will be important that we get that report, because as this collective we have ensured that as we do our work, we are going to make sure that we mend relationships of the department and we enforce that department must work together, more especially on dealing with issues that we know that they are mostly affected by budgets. And we know we never had sufficient budget. Since I've been in Parliament, even from NA, the cry has been insufficient budget. Whether through the medium-term budget review, we will still say there's insufficient budget. But we believe that if we all cooperate, coordinate our work and deal with duplication, we will be able to do more with what we have. So I want to thank you, members, for your participation. And I want to say, let's continue moving together so that we become victorious as members of Parliament, not only for ourselves, but for the people that we are representing as elected people. With that being said, I want to adjourn this meeting and thank you for maximum participation. And Nkosi, thank you for weeping as well when you had to, in terms of giving the directive. We want to adjourn this meeting with peace, that let's continue representing our people and do the just for their services. Thank you. The meeting stands adjourned.
Thank you, Chair.
Thank you very, very much. Thank you.
Thank you, Chair. Sharp colleagues.
Chair.